Mama's in the living room watching Judge Judy. I'm in the kitchen eating leftover sushi, and she goes, oh, girl, you gotta hear this one. A man was arrested for running the theme park, and when they said, where's your license? He said, my dog ate it. Oh, you can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. Girl, you gotta hear this one. Mama loves to laugh at how absurd life is, says it's all a comedy and I'm her audience. And I love the way she makes fun of the world. She said, you'll never guess who with their girlfriend. It was a man who didn't get us out of the bed. He said, I've been through hell and now I need some help. You just can't make this shit up. You just can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. Girl, you gotta hear this one.
The bullet matched. The bullet didn't match. It was inconclusive. And I have some demonstratives to show you why. Welcome back, everybody. So today we have a Tyler Robinson hearing. We are going to be live. We are waiting on it. I have it right here. However, it is obviously there. So we do have all the documents. In addition to the newly released ATF report that is in this 19-page motion from the defense that was newly released. It was filed in January. However, the defense wanted to keep it sealed, and it was released. And thanks to Andrea Burkhart and her Substack, all the documents are posted on her Substack, on her paid Substack. I do have access to it thanks to her for getting all these documents instead of having to pay the state of Utah every month, which would be ridiculous. However, in this report, and we are going to look at this report first, because there is something interesting in it. The ATF report that is in question. If you remember 2 weeks ago-ish, we talked about the ATF report and what they didn't show you or what they didn't tell you. And I have my other computer over here, so because I took notes when I was reading it, because that's what I do. But I also have some demonstratives. And YouTube, do not this is where I'm gonna need y'all to send that like Starbucks money if you got it, because I have out of my own closet. These live in my closet along with the items that they go attached to. We have a 300 Blackout. These are the closest for comparison that I have without going out and buying ammunition for weapons that I don't have. And this is a 338 Lapua 338. This is the same width, I guess you could say, caliber as the 30-06. It is a 300 Blackout, not the same size bullet. Obviously, for those of you who are firearms experts in the chat and on Replay Crew, do not come at me. I am not an expert. I just am former military. I like what I like. I am using what I have in my closet. These are personal things that I and my spouse own. This is the closest that I have in comparison to like size, diameter. This is the closest that I have in comparison to the range that a 30-aught, the weapon in question would shoot. This shoots about twice as far as the weapon in question. This shoots over 1,000 yards. This shoots sub 200. So together, these are as close as I can get. However, these are these both live in my house. This is my favorite by far, and this is the one that this is our snipe, our one where we can see you coming from a mile away. Put it that way. Yeah, it's a tweener. Like I said, firearms experts in the chat, do not come at me. I don't have the exact caliber, and I am not going out to buy the caliber for a rifle that I do not own. 30 ought to be enough, said no PV collector ever. Yes, and before we get started, thank you, Unhung Hero, for the 10 Squid Pro Quo memberships. I appreciate you very, very much, as always, and I hope you and the missus are doing well. So, I have those because I wanted to demonstrate when they are talking about bullet fragments, just how tiny we are talking. This is a bigger caliber than the bullet in question. And imagine putting that into 6 pieces, trying to put it together and telling what bullet or what weapon it came from. The reason I have this is because I want to show you just how small of issues we're talking about. You can hear it and it sounds good. And you think you know what you're talking about and you think you know the size, but when you're like looking at it, and be it this is bigger, but even if this were to split into 6 pieces, and we're talking about just the tip, if this were to split into 6 pieces, and you were to try to put those 6 pieces together and then try to tell what weapon it came from, it is not an easy science. It is not an easy act to do. So, with that being said, when something is seen as inconclusive does not mean does not match. Inconclusive means inconclusive. Yeah, that's what he said. But I wanted to give you the comparison of this is more accurate to the size than but this is the width or the diameter. So it's a tweener. Neither one of these are accurate to the size of the cartridge used. However, this is as close as I could get to what I have in my collection. 5.56 is the next other thing that I have, but also not even close to accurate. So don't come at me in the chat, because y'all. So basically in this motion, Mr. Robinson requests that the court issue the following orders. They want to prohibit the state and its agents, meaning the federal government. Hold on. No. I got to turn this down. Hold on. And for those of you who are upset or angry that my little is here, yes, she makes noise. I have a 3-year-old daughter. Suck it up, buttercups. If you don't like me, have a blessed day and have the day that you'll do. Mom. All right. All right. So an order permitting the defense, so the state and its agents, meaning you got to get down. The FBI and its agents from permitting further testing of the bullet jacket fragments pending the outcome of this motion, and an order permitting the defense. No, you stop.
please?
No.
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 Stop.
No.
Stop.
Go see if Daddy's home.
No.
An order permitting the defense meaningful opportunity to examine and photograph this evidence before it's further altered or destroyed. In the alternative, an order permitting either the defense expert observation of any further alteration and testing of this evidence, or requiring video or recording such alteration. And they go into why. However, we are going to look at what is the most important in this, in my view, is the actual report. So they put in here the state's notice of intent to conduct non-destructive testing. And even non-destructive testing does alter things. It is what it is. It's non-destructive, but it does alter to a degree some things. 1 bullet jacket fragment and 4 lead fragments were recovered from the body of Charlie Kirk during his autopsy. The FBI lab intends to conduct forensic testing on the bullet jacket fragment and at least 1 of the lead fragments. While the testing will not destroy or consume the fragments, it may alter their character. While the testing bullet jacket fragment, the FBI lab intends to conduct virtual comparison microscopy analysis of the bullet jacket fragment to examine any markings that the rifle imparted to the fragment. This analysis is non-destructive and employs 3D technology to capture multiple scans. The object is placed on a platform for scanning. The scanning instrument's optical head does not contact the item. The scan data will be preserved for future use, allowing any generated scan files to be produced for independent VCM examination analysis. Okay, they're not touching it. I get it. Great. We're all good. However, you're still touching it. Well, you're still, yeah. So this one I don't have a problem with the state or the state or the FBI or the ATF or whoever's doing it, because of it's not actually being touched. The examiner has informed the state to obtain a useful scan of the bullet jacket fragment may be necessary to fold back portions of the jacket fragment to allow the optical head to capture the surface of the jacket that contacted the rifle. This is what the defense has issues with. I don't know what I feel about this. I have to talk to Mr. Squid about this. He has been busy all morning. I have not actually been able to discuss this report with him to see what he thinks, because he is he is my expert. I like the Second Amendment. I like the things that go, or that these things go inside of. However, he is my go-to person for all questions, because I just know what I know, but I don't claim to be an expert. Which, Hey, Christine, how are you? All right. While this process leaves marks on the surface of the fragment, the examiner will document those marks and, if possible, ensure the marks do not interfere with the areas to be examined with VCM. Although this process may alter the shape of the jacket fragment, the examiner believes that the item should remain intact. This item is nevertheless fragile. And Christine, thanks for being a member for a month. I appreciate you. We're doing members only Mondays now, and we're coming up with a TEMU Law School. And I have a feeling that one of the lawyers for Tyler Robinson, aka Kathy Nestor, is going to be on the TEMU Law School Lawyer Prep Academy faculty list. I just have a feeling. The ATF previously conducted light comparison microscopy analysis of the bullet jacket fragment. See September 17th, ATF lab report at 2. ATF lab described the item as a .30 caliber class deformed, damaged bullet jacket fragment. That's important, because when you say the bullets did not match, guess what? The rifle, there's going to be some interesting thing in this report, and even though they were inconclusive, you are going to hear some things that do line up with the other evidence that we've heard. Hey, Inspire, thanks for being a member for 15 months, jumping in to say hi. I love your work. Thank you so much. I appreciate you. Even though I'm not relevant or trying to be, I don't know what the hell I'm trying to do. I heard some people sent some screenshots last night. I don't know. It's funny. It's funny. It's the state's understanding that the examiner who conducted these prior LCM analysis may have already folded back pieces of the bullet jacket fragment to expose its exterior surface. And after the ATF examined the bullet jacket fragment, it sent the fragment to an FBI lab. An examiner at the FBI lab noticed when the FBI lab received the bullet jacket fragment, it appeared that a small portion of the fragment was detached from the main portion. Given this, the FBI examiner stated it's possible that additional pieces of the fragment may inadvertently become detached during the VCM analysis. I laugh. Here's the thing. If I wouldn't take advice from someone, I don't take criticism from them either. So we do have the seal of the state of Utah. When this goes live, we will go live. But until it does, we will just be Oh, it was the same person who said I was going to be sued for reading legal documents. Like it's old news. It's just funny. It's just hilarious to me. All right. The lead fragments, state also intends to conduct metallurgical, and this was back January 9th when this whole document was posted under seal. The examiner will document the area which the scraping is taken. The metallurgical testing will not prevent an independent expert from conducting the same analysis by taking a scraping from another area of the recovered fragment. So that was dated December 22nd. This was attached to the defense's January 9th. Yeah, and there's our favorite Corey Richins failed attempt. But here's the most interesting part. And I have to mute that. Hopefully the audio in this courtroom will be better. Although I did get hater comments that it was my daughter making the audio suck and not me and not the courtroom audio. But you know, whatever. All right. So this is the ATF report that we've heard so much about, but now we're actually seeing it. And remember the headlines, the bullet did not match. Remember those. 1 Mauser Model 98 30-06 Springfield caliber rifle bearing that serial number with an optical accessory. 1 30-06 caliber cartridge case, the expended case. 1 30-06 Springfield caliber cartridge. 1 30-06 Springfield caliber cartridge. 1 30-06 Springfield caliber cartridge. 1 bullet jacket fragment, and 4 lead fragments designated 6A through 6E. The results. This report refers to exhibits by lab number. The following results only apply to the items tested. The Exhibit 1 rifle was test fired and found to be in operable condition. Remember that. That's important. The rifle that was found that belonged to Tyler Robinson's grandfather was in operable condition. Very important to the tinfoil hat conspiracies. That rifle didn't even work. That's one of the conspiracies that I've heard. That rifle was just for show. It didn't even fire. How could he fire with a weapon that didn't work? Remember, on this channel, we don't deal in conspiracies. We deal in facts. It is just what we have to do. Oh, and I forgot I have stuff on this channel or this computer too. Let's see. I have two different feeds up, two different view or ABC4 Utah on this one and Fox Now on this one, or Live Now from Fox, to see which one actually goes live first. And right now they're just giving me really bad audio. Those Mausers never fail. Yeah, I've heard they're pretty reliable. I've never shot one, but I've heard they're pretty reliable. But that's important to remember because that's one of the things that it didn't actually work. The weapon wasn't operable. All right. Exhibit 2 consists of one 30-06 Springfield caliber fired cartridge bearing a Remington head stamp. And the head stamp is, I'm going to see. I got to make sure it's right side up. Is that. Let me turn on my light. I'm sorry. I woke up with a little bit of a headache this morning, so my lights, I didn't have them on. But you can see the markings, and they are very hard to see because they are very small. Ugh. But the head stamp is right there. I know it's kind of difficult to see, kind of hard. See if the 300 Blackout is any easier to see. Let's put that one on. There we go. That light's better. And you can kind of see it. Apple pencil size comparison. I don't have my Apple pencil. It's in my purse. Let's try again now that that light is. There we go. You can see it. The stamp. But it'll tell you, for anybody who's not familiar with any weapons, it'll tell you what caliber it is, who makes it, that kind of stuff. 338 Lapua. That's my big boy. That's my beastie. That's my beastie. Like, I am not an expert, but this is my favorite. This is my favorite. This is my favorite, my 300 Blackout. All right. Oh, snipe. Yes, thank you. Thank you. I will bring it up. Snipe Hunter just sent me a picture of the projectile. Let me share this. Let's see if I can take an image file. Hold on. Save image. I appreciate that. Let's stay at the document. All right. Whoop. We do have the start of the
Court is now in session.
perfect timing.
Video recording may begin. Calling case number 251-501-576, State of Utah versus Tyler James Robinson. Counsel, could you please enter your appearances?
Chad Grunander, Lauren Hunt, Ryan McBride, and Chris Ballard for the state here in the court today, Your Honor. County Attorney Jeff Gray is joining via WebEx, although I don't believe he will be making an appearance at today's hearing.
All right, thank you and good morning.
Good morning, Your Honor. Kathy Nestor, Michael Burt, Richard Novak, and Stacy Visser here on behalf of Mr. Robinson, who is seated beside me.
Good morning to defense counsel. Mr. Robinson, good morning to you as well. All right, before addressing the business that's before the court today, I want to address some preliminary matters. First, with respect to courtroom protocol, To maintain security and decorum, and the individual who exits the courtroom during these proceedings will not be permitted to re-enter until the recess. So I just want to give you that heads up. All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices and care to avoid the inadvertent capture of privileged or private discussions by recording equipment or by those present in the courtroom. Second, I wish to address the camera operator and still photographer, if you would both come forward.
Oh, you're getting a talking to before we start. Don't
All right.
fuck it up.
I don't
Excuse my
mean to
language, but
cause
don't
you any
fuck it up.
discomfort, but I just want to ensure the expectations of how we're proceeding today. Could you state your names and your respective roles, please?
Trent Nelson as the still pool photographer for the Salt Lake Tribune.
Thank you, Mr. Nelson.
Adam Fondren, video pool for ABC4.
Thank you. All right. Have you both reviewed the court's standing decorum order dated February 24th, 2026?
Yes.
Yes, Your Honor.
And do you understand the requirements set forth in that order as it applies to your activities today?
Yes, Your Honor.
All right. Do you require additional time to review the order or to adjust equipment to ensure compliance?
No.
No, Your Honor.
All right. Do you anticipate any difficulty with complying with the order?
No, Your Honor.
All right. Well, Mr. Nelson, Mr. Fondren, I appreciate your cooperation. Thank you.
Thank you.
Turning next to discovery, counsel for the state, could you give an update?
Your Honor, on April 3rd, I filed a notice of the state of discovery with the court. I don't know if you've seen that, but I attached to that filing a 225-page document that lists the discovery that have been provided as of April 1st of this year. There's over 20,000 files. That document has about 100 files per page listed. Discovery continues to come in. I believe it was March 26th, the defense counsel sent a discovery letter requesting special discovery or specific discovery of materials, case files, underlying data, and so forth of lab materials from scientific reports. We're going to address some of that in the motion to continue the preliminary hearing today. Those materials have been requested from the FBI and ATF labs. Both laboratories are responding to that. They're reviewing it and they're providing information. As of Saturday and Sunday of this week, ATF, or some weeks ago, ATF provided to SBI their entire lab files, their entire case file. On Saturday and Sunday of this week, SBI was able to process much of that material, and we were provided at our office about 1,700 files from the scientific reports from the ATF. Just last night, I was updated that we received some more of those files, and that discovery continues. We're processing that material, bait stamping, cross-checking for duplication, and then providing those materials as efficiently as we can.
Thank you, Mr. McBride. Appreciate that update. All right. The court will now, and to the other parties, did you want to weigh in or comment on that?
Thank you, Your Honor. Richard Novak for Mr. Robinson. I think the status of the specific items of discovery that Mr. McBride was just mentioning is sort of the core of the present dispute about whether the preliminary hearing can go forward in mid-May. So I guess the best thing to do would be to reserve comments about that until the court wants to take up that motion.
Thank you, Mr. Novak. I appreciate your input on that. Well, turning to that, I do want to outline the procedure for today's hearing, and it's to do so in an orderly and efficient presentation of the issues before the court. First, we'll be addressing the motion to continue the preliminary hearing, which is set for next month. And what I want to do is I'm trying to manage time as at the same time allowing all parties the ability to present what is necessary in order for this court to make a well-informed decision. And so here's where I'm landing. As it relates to the continuation of the preliminary hearing, I will allow both sides 30 minutes to present what you wish to present to this court. This would include any allocation for rebuttal for defense. Upon conclusion of argument on that motion, the court will proceed to the pending motions concerning media access within the courtroom. Each side will be afforded up to 2 hours to present argument, examine witnesses, cross-examination, and redirect and respond to inquiries from the court, as well as reserve time for rebuttal. So I just want to create that expectation. Knowing the expertise and experience of the parties, that's probably more time than you need, but I want to create an expectation so we know how to proceed. I encourage the parties to be succinct in presenting the evidence, and the purposes of these time allocations is for case management and not to alter or diminish any of the parties' substantial rights. Following the defense's presentation, the court will recess for approximately 30 minutes, during which time the courtroom will be closed. Proceedings will then resume with the state's presentation. If necessary, members of the media will be thereafter afforded up to 15 minutes for any responses. The court will then take a brief recess of approximately 10 minutes. Upon reconvening, the parties may proceed with closing arguments using any of the remaining allotted time. The court will monitor the time and argument will conclude upon the expiration of that time. The court anticipates issuing its ruling at a later time via WebEx, as you may come to expect, to permit full and careful consideration of the record and the arguments presented today. The scheduling of that proceeding will be addressed at the conclusion of today's hearing. The court recognizes the significance of the matters before it and the preparation undertaken by all counsel. All participants are expected to adhere to the applicable standards of professionalism, civility, and ethics. The court finds most helpful those submissions and arguments grounded in the evidentiary record and supported by controlling authority and applicable law. Counsel are expected to ensure that their witnesses conduct themselves in a manner consistent with these standards. The court will now turn to the defense.
Let's see what she's got. What's his name?
Mr. Novak.
Novak.
Thank you, Your Honor. Richard Novak for Mr. Robinson.
This was
Your Honor,
if I'm remembering correctly, this was the Menendez brothers lawyer. One of the lawyers on Tyler Robinson's team was the lawyer for the Menendez brothers in California. I think it's him. Flash Fan would know better than me. I just can't remember, but Flash Fan is busy right now. So I only entered the mini today. I missed something. How are you today?
the three docketed pleadings that are germane to the defense's first motion to continue the preliminary hearing are our motion, which is docket number 466, state's response, which is docket number 476, and our reply, which is docket number 493. I can keep track of my own time, but my expectation is that I won't need all 30 minutes, but whatever I don't use, we'll see if any rebuttal is necessary.
The expectation is that you'll talk a little damn faster.
I think, if I may, the last time we were here and there was sort of a preliminary discussion about the May setting for the preliminary hearing, I think I said to the court, I don't need to reiterate what the court said to us when it set the date. But I do think, in light of the status of specific items of discovery, which I will get to, and the state's position on whether the preliminary hearing can go forward, I do want it to be clear, at least for the record, because I obviously understand that Your Honor knows what the court said, that the expression of the court back in December was that no party would be prejudiced
by this setting. And I think that's important because when we look at the status of discovery with respect to the specific scientific evidence we're talking about, and we look at Article 1, Section 12 of the Utah Constitution, and we look at Rule 16, and we look at Evidence Code Section 1102, it is clear that Mr. Robinson is prejudiced by the preliminary hearing going forward as scheduled at this point, and it can't even be remedied in the next 4 weeks. I very much appreciate the update that Mr. McBride provided. He actually provided that to us before the hearing. But the bottom line is that we don't have from the prosecution team, and I'm going to explain what I think the prosecution team means in this context, data which is in their possession, which is clearly discoverable under Rule 16, which is what the Constitution of Utah refers to when it talks about appropriate discovery. And that brings up the reliability question under Evidence Code Section 1102. So there is no doubt that the ATF and the FBI have data files that represent what I'll call the digitization of DNA evidence. The DNA evidence, literally the collected evidence, is physical evidence, which is specifically addressed in Criminal Procedure Rule 16A1C. And then when it's digitized, and it may be that experts will tell me that's not the right word, but when it is converted into data that can be analyzed, data sets that can be utilized in DNA analysis, that's electronic evidence under Rule 16A1C. And we don't have that, and Mr. McBride acknowledges that we don't have that. And when I say we, I mean the defense from either the ATF or the FBI. Now, Mr. McBride, I think, said to the court, he did say to me, that the ATF has just recently given SBI some files. SBI has turned over some of them to the Utah County Attorney's Office, but not all of them. The defense has not yet received them. So neither Mr. McBride nor I actually know if these data files, the raw data upon which all DNA analysis has been done, or have been produced from the ATF to SBI, and we don't know if it's gone from SBI yet to the Utah County Attorney's Office. The FBI has not turned over anything, according to Mr. McBride, that might include the data files because there has been no production by the FBI in recent months in what I'll call the DNA area. We did make what Mr. McBride called a supplemental discovery request some weeks ago that set forth with great specificity the forensic related documents and materials that we want, including those data files that's actually attached as an exhibit to our motion. But that was not the first time that we asked for these data files. And I am not casting aspersions at Mr. McBride and his team, because those data files are in the possession of their federal law enforcement partners. We're not asking somebody to go looking for a needle in a haystack. Hey, there might be some piece of evidence somewhere. Can you go looking? We know that these data files exist because we have summary FBI and ATF reports summarizing the data analysis that go all the way back to September. So I actually think that one of the questions, if I may, one of the questions, because counsel don't ask each other questions in the courtroom. We understand that all questions are asked by the court. Why hasn't the FBI turned over these data yet? And why hasn't the ATF clearly communicated until very recently whether it has and why it has not? The state's opposition to our motion does not explain why the data files have not been turned over. So now what I want to talk about is the significance of the data files. We have a right at a preliminary hearing to both examine and cross-examine witnesses. And our right to present witnesses includes presenting expert witnesses. If the state doesn't want to call the forensic examiners at the FBI and the ATF to testify about their analyses and the conclusions, that's their choice. But we have a right to present evidence that gets at these DNA issues, and we have a right to do that through expert witnesses. We can.
I agree with what he's saying. The problem I have is the state can't, well, the state shouldn't have to turn stuff over until they know what they're turning over, which means they have to go through it once they get it from the FBI. I'm not sure how this case compares to your average case as far as a case like, what's his name in Wisconsin, Nikita Kassap, with all the data files that they had and how long that should take, because the FBI had a bunch of data in that case as well. However, this dude's argument is falling flat with me. I want to agree with what he's saying, but he talks so slow that I'm losing interest in his argument the more he talks. I don't know if that's happening with anybody else, but this is my problem with when I live stream trials and stuff, why I have to do it on 1.25 speed. Because when someone talks so stinking slow, it takes me back to my first anatomy and physiology professor in college, who was monotone, flat, and I could not follow what he said. I lost interest and I got bored. And when I get bored, my ADHD, my cognitive impairments start to take over, and I start to dislike somebody. And when I start to dislike somebody, it doesn't matter how well their argument is prepared, how smart they are, how good of points they have. When I start to not like you as a person, anything you say to me, I could care less about. And I'm starting to not like this guy as a person because he's boring me to death.
Not do that when the law enforcement partners, ATF and FBI, have not provided us with appropriate discovery. That's
Mama duties.
that's the phrase in the Constitution, appropriate discovery. So that appropriate discovery is the gateway to reliable hearsay at a prelim. It is meaningless for us to have the right under the code to present and cross-examine, present our own witnesses and cross-examine witnesses when we don't have the electronic evidence, that is these data files, that comes from physical evidence, the DNA swabs. It's a meaningless right, and it frankly makes a mockery of the reliability concept. We have identified for the court in public pleadings 2 DNA experts who we have retained who are waiting for these data and for other materials so that they can advise us on whether the opinions expressed in these reports, these are ATF and FBI forensic reports on the results of their DNA analysis, whether these reports are reliable. And if they are, if they're not, cannot be determined without that underlying data, those underlying data. So we have the experts, they're waiting for the data. We don't have the data. It's not Mr. McBride's fault. It's not SBI's fault. It's the law enforcement partners who have had these data files since September. Like, it's been over 6 months. And many of the DNA reports that they produce are also dated September. And I could go through each one of them if necessary, but maybe I'll do that in rebuttal because I don't want to run out of time. So we can't present any expert testimony on DNA without having the underlying data. Second step, if the state doesn't want to call the forensics examiners from the ATF and or the FBI as witnesses, we also have the right to call them as witnesses. We have a little bit of a jurisdictional problem because we're in state court and we're not in federal court. And so we have these TUI regulations, which I'm sure the court is familiar with and are addressed in our reply brief. And I have personally been in contact with counsel for the ATF and counsel for the FBI who have not said, yes, we will make these witnesses available. They have said, why don't you get us some subpoenas, which are, by the way, not enforceable, but they're subpoenas. And could you give us a more definite statement of exactly what you want them to testify about? But I can't examine those witnesses without the data and without the data files being evaluated by our DNA experts. The state suggestion that we just put these reports in through Rule 1102 before really calls into question the concept of reliability, because there is no way for this court to evaluate the reliability of those conclusions. There is no adversarial testing if I don't have those data, if I haven't been able to give those data to our DNA experts, if they haven't been able to tell us what they think of the data vis-a-vis the conclusions in the reports. So we have a problem with adversarial testing. It's a critical stage of the proceeding. We are basically handcuffed under the state's proposal, which is the court receives into evidence reports which we cannot in any way address the reliability of. And so this actually goes all the way up to the Utah Constitution, which says that reliable hearsay is admissible if we have appropriate discovery. Appropriate discovery, again, is the constitutional phrase. But it also implicates, because it's a critical stage, Mr. Robinson's Sixth Amendment right. And as I addressed in our reply brief, the heightened reliability concerns that the Constitution reminds us of in any capital proceeding. And heightened reliability isn't just reserved for penalty phase. And I provided the court with a number of cases which talk about heightened reliability being something that is a gloss over the entire proceeding. So the court, in my opinion, needs to, and in light of the law here, needs to say to the state, I can't do the prelim until the defense has the data files in a reasonable period of time. When are we going to get the data files from the ATF and the FBI? And if Mr. McBride, given all of his due diligence, can only say to the court, I don't know, because the FBI hasn't told us when, and the FBI hasn't told us why, then we're just going to have to wait. We're not interested in postponing this for the sake of postponing this. We're interested in having a meaningful testing of expert reports, which the state wants the court to just receive into evidence under 1102b4. And that's not reliability. That's not reliability under the constitutional test, which requires appropriate discovery first. It's not reliability under the 5th, 6th, and 8th Amendments. And I'm not in the business of telling the prosecution in any jurisdiction how they should do their job, but The state chose to proceed by way of preliminary hearing instead of proceeding through a grand jury. And this is where we are. We have a right under the Constitution to have appropriate discovery before this court receives into evidence what the statute says is reliable hearsay. And if the court says, oh, you don't need the data files, then we believe that 1102B4 is unconstitutional, as applied in this case. If we
I
have the
don't
data
disagree.
files and a meaningful time to evaluate them, then the state has fulfilled its obligations under the Constitution, and the reports can be received at least statutorily as reliable hearsay, subject to our right to present evidence through direct witnesses and through cross-examination. So I think, other than what I've said so far, I would be repeating myself. And if I've not used my 30 minutes, then I'll save the remainder for rebuttal.
Thank you, Mr. Novak. Turning to the state.
I mean, I don't disagree with that argument. There's questions that I have as to what is taking the FBI so damn long to do it. Yes, I know things take time. However, last stream we did, when we did our March document recap, we looked at all the different bureaus of investigation and police departments that were giving information to one entity who was giving it to the Utah County Prosecutor's Office. In that case, is there something that is not working right and somewhere along the line the ball is being dropped? I'm curious. I don't know. Everything could be going according to plan. It's just taking a long time. Or is somebody not doing their job up to par and it's taking longer than it should? These are just questions I have. Not a lawyer. These are just factual questions that I have as to why things take long. But I agree with the lawyer. I just don't like that lawyer because he talks so damn slow and his voice drives me nuts. His voice wants to put me to sleep. He makes me need more caffeine. And that's like, he's the type of lawyer that I would like have books read to me, like that kind of person. Not the person who I want to stay awake while I'm trying to listen to court hearings. But it's just, why is the prosecutor's office not just being like, okay, we agree, judge, can we push it back? Why are they trying to rush it? To me, I don't believe in the conspiracy theories. I will tell you that. I'm not sure if I agree that he's guilty, but I'm sure as hell not believing that a foreign country did it or his wife did it, like people are trying to tell you. However, it is not the appearance of transparency and all of that is when you are fighting, pushing back this hearing, what are you trying to hide? And it just makes me question things because I don't like the state. I am, with every trial that I watch, I become more of an anarchist. I will not lie. I become more of an anarchist. I hate the state because in general, the state and the judge are technically on the same team. They're both paid by the government. They're supposed to be independent bodies, but they're both paid by the same team. So I hate prosecutors in general. Like I hate lawyers. If you don't know me, this is your first time seeing me. Hi, my name is Heather, also known as Squid Pro Quo, and I am not a fan of lawyers. I am not a fan of people whose egos think they're the smartest person in the room. Not a fan. However, when you're fighting something that seems so damn obvious, we haven't gotten all the discovery yet. According to Brady, we need all of the discovery. We're allowed to cross-examine witnesses. We can't cross-examine witnesses if we don't know what the witness is going to be testifying about. That seems pretty damn fair. And as much as I'm not a fan of Tyler Robinson, and I'm really not a fan of his lawyers, Kathy Nestor, I think, is horrible. She's like the Utah version of Elaine. If you know, you know. What, if anything, would it be a problem if we pushed back the preliminary hearing? How would it prejudice the state? Oh, it wouldn't. But it would give the defense a chance to go through all the data. And if you have nothing to hide and you are not trying to rush things, why are we trying to push back the yeah, and that's one of the reasons that I hate the state. I understand timely trials and getting things done and not wasting time, but I also, if it's Tyler Robinson today, it's us tomorrow. Like, I don't have to like somebody to still understand that innocent until proven guilty, and you have constitutional rights. And if it's his constitutional rights today, it's any of ours tomorrow. And we got to all hate the government together, because we don't hate the government enough. Like, and in Minecraft, YouTube, in Minecraft. We'll catch the replay. Thanks, Squid. Take care. Please stay safe. You have a great day, Anne. I will see you later. Thanks for hanging out with us while you could. Maybe that's the goal. Put the jury to sleep so they can't hear the evidence. You know, I don't know, but we'll see what happens.
Is that okay if I disconnect it?
Yeah, sure.
And I do have all the docs. We will finish the ATF report at the recess.
Trina, do you mind allowing me to present?
Mr. Squid is not home, but I don't know when he's going to be back because the little has his phone. So I'm assuming he went shopping.
Your Honor, the court should deny defendant's motion to continue the preliminary hearing simply because the reason the defense has requested to continue the preliminary hearing really has nothing to do with the preliminary hearing.
Wait, what?
It's unnecessary. The continuance is. It's necessary to expert discovery. It's necessary to expert notice. It's necessary to a 702 hearing. It's necessary to a trial determination of the weight to give to expert testimonies, but it is not necessary to a preliminary hearing. Now, before I jump into my argument, Your Honor, is my screen sharing?
No, this isn't a trial. This is just a hearing on whether they're going to continue the preliminary hearing, and also motions on whether to allow cameras in, because the defense is still trying to keep cameras out of the courtroom for everything that is important. They are still trying to file motions under seal because they don't want any of this public, because they think it will prejudice their client. Welcome to 2026, where people want transparency, and we want transparency in our court system. And I'm sorry, but if you don't want transparency in our court system, you are one of the reasons that society sucks. Amos girl, how are you? King Bob, how are you doing today? How are you feeling? How is the queen, and how was her birthday? Did she have a good birthday? But I don't see what, like, I don't see why, if you were going to present witnesses at the preliminary hearing, which it sounds like they are, or the defense made it out to sound like they were. Whether that's true or not, I don't know. But if the prosecution is going to present witnesses at this preliminary hearing at all, the defense has a point.
Can you see it there, Your Honor, on your?
Well, let's see.
We're not seeing anything at council table.
I'm not sure if it's being presented yet.
He hasn't entered a plea.
Sure, I've got
I
this here.
think they are. I have never personally seen a defendant wait this long to enter a plea. Usually it's pretty like at their arraignment, they plead. I've never seen, I could, like I said, I don't watch every single trial all over the country, so obviously I could be wrong. This is not an all, this is just what I have noticed. However, this is different.
Don't.
So,
Don't
but good to
my
see you,
tracks.
Obi 711.
Down my tracks. Down my tracks.
Well, I'll assume that will come up as I'm talking, Your Honor. But before launching into my argument, I want you to understand my structure here, okay? My first point that I'm going to make is the defense has not shown that a continuance is necessary to the purpose of a preliminary hearing. Maybe necessary for other reasons, this material, but not necessary. Maybe this material and discovery of this material is necessary for other purposes, but not for the limited purpose of a preliminary hearing. And the second point is the rules don't require expert notice before the preliminary hearing. Look at Article 1, Section 12, Rule 16, Rule 7B, Rule 1102. They don't require expert notice before the preliminary hearing. Now, I want to start with that first point, which is the real standard, the salient principle from whether it's Long, Prior, or Lopez is
Work is
you
overrated.
don't grant a continuance unnecessarily, right? Axiomatic, right? That's the salient principle from those cases. That's what common sense says. You don't unnecessarily continue a hearing, right? Why? Well, because it causes delay in the proceedings. In this circumstance, this is not a nominal delay. We're talking at least 6 months for the defense to get this material, review it, and consult their experts, and for their experts to be ready to present expert testimony. But more likely, even more than that, because there's litigation surrounding some of this expert investigation. One of the tests right now has not been performed because there's an objection to it. And we're waiting to litigate that issue, depending on what some of the expert discovery shows. In addition, we're probably going to object to some of the expert discovery requests the defense has made and that they made on March 25th. So this is at least a 6-month delay, probably much longer than that, because some of these expert issues have to be litigated. And when you consider the purpose of the preliminary hearing, right, it's an initial stage of this process, right? It's designed to protect a defendant from having to sit in custody and wait for all the trial preparations without there being any showing of any evidence, right? The Rule 16, the preliminary hearing is designed to ferret out groundless prosecutions. Probable cause is a very low standard. Reliable hearsay is admissible. The court doesn't weigh the evidence at this stage. And that's because this is a very early stage of the proceeding. And the rules contemplate discovery and investigation ongoing throughout and even past the preliminary hearing and even all the way up until trial. So the question is a continuance necessary for the purpose of a preliminary hearing? And to understand that, you have to understand two things. One, what is the purpose of the preliminary hearing? And two, what is the evidence that's likely to be presented at the preliminary hearing? And then you get to three, is a continuance necessary? First, the purpose of a preliminary hearing is clear. There's very few principles in Utah law that are more clear than this. There is one purpose to the preliminary hearing and one purpose only, and that is to determine probable cause. Every time a defendant or a trial court tries to expand the preliminary hearing beyond that, whether it's on constitutional due process grounds or discovery grounds or something else, the courts uniformly and repeatedly reject those arguments. There's only one purpose. It's clear in the Constitution. It is to determine probable cause. It's not a discovery hearing. It's not a due process notice hearing where the defense learns what the state's theories are or what evidence the state is going to present at the trial. It is not a suppression hearing under the Fourth Amendment. It's not an admissibility hearing under the rules of evidence. And it's certainly not a 702 hearing. It is only one thing, a probable cause hearing. That's it. That's important because that relates to what a continuance being necessary means, right? Can the defense show they need to continue this hearing because it's necessary to a determination of probable cause? If they can't, it's unnecessary and it's going to infringe on the victim's right to a speedy trial. as well as the state's ability to present the case. Justice delayed is justice denied, as the saying.
OB711, thank you for the $10 super sticker. I really appreciate it. And I see the prosecution's point. I really do. It is just a preliminary hearing. It's a probable cause hearing at the end of the day. However, like, in the interest of transparency, I see the defense's point too. I don't think that the judge right now will grant the extension. I'm just like, if I were to take a guess just based on now, I don't think the judge is going to grant the extension. It's a probable cause hearing at best. If they are going to present witnesses, then he will. If I think there will be a rebuttal from this, this is one of those where I see both points, and this is where being a judge would really suck, because there is no 100% right answer, because both sides have a good argument. Bruce Manskin. I love the play on words. What kills me on trials is when you have a video of you doing the crime. Now be the man or woman, do your time. Quit wasting money on a trial when you're already guilty. Yeah, that's the problem in the case that Mo's covering right now. He pled guilty, and they're just basically doing the entire trial as a death penalty issue. And it's like you're going through and wasting them. It seems like a big waste of money. But yeah, he hasn't even pled yet. So it could be where he ends up pleading guilty, and then this is just a waste of time. But he hasn't pled yet, so we don't know. This is all speculation. The defense hasn't advised of any reason they think the state has the wrong person. They're quibbling over access to evidence, not the possible innocence of their client. Well, right now they don't have to. That's the other thing. Right now, we haven't even gotten to the probable cause hearing. So like right now, it's all here nor there, and it's a death penalty case. So at the end of the day, their main goal may be to keep their client alive. I don't know what's going through their head, but this is Kathy Nestor, and she hasn't had good luck with unaliving trials lately. So we shall see. We shall see. Just for the record, I was against ever letting Utah become a state. Noted. I'm just. Oh my goodness.
Saying goes, and that's because it affects a victim's right to a speedy trial. It affects the public's perception of legitimacy of the prosecution and the judicial system, and it has real effects on the evidence that may be presented at trial. Witnesses become unavailable, memories fade, evidence grows stale. And so the court should not be granting a motion to continue and delaying the proceedings unless it's necessary, especially for such a lengthy period. The next stage in understanding whether or not a continuance is necessary is, one, understanding the purpose, the limited purpose. Two is, what's the evidence going to be at the preliminary hearing, right? Because if you understand what the evidence is going to be, then you can determine, well, is what the defense wants to present, is that going to affect the probable cause determination, right? The only way to know that is to know kind of what the evidence is going to present. That's why Lopez says you listen to the evidence first, and then you should consider, in that case, whether or not the defense should be able to subpoena the victim. And I think the same analysis applies here. Listen to the evidence first, then you ask the defense, well, what are you going to present? And will it be necessary? Will it be relevant to a probable cause determination or not? Put another way, will the defense be able to show that whatever evidence they want to present is likely to defeat probable cause? If they can't make that showing, it would be an unnecessary continuance. So let me give you a proffer of what the evidence will be at the preliminary hearing. There's really four categories of evidence. The first is surveillance from UVU. Now, UVU has a great surveillance system, and they capture the defendant coming on to campus at about 7 a.m. or I think about 8 a.m. Okay, it's clearly him. He's driving his gray Dodge Charger. I should say he's from St. George, so this isn't just a casual passing by Utah Valley University. This is a 3.5-hour drive from his home, 250 plus miles from his home. They capture his car pulling into the Utah Valley University parking structure. He gets out of the car. He's wearing his favorite Hurley hat, a maroon t-shirt, shorts, and Converse shoes, the same clothing he's wearing when he turns himself in the next day. Clearly him. There's good facial images and everything. He walks around campus and he scouts campus out. He then leaves the campus. UVU surveillance then captures him return later. He returns on foot right before the Charlie Kirk event. He's wearing a disguise of sorts. He's wearing a baseball cap, different baseball cap, pulled low. He's got sunglasses on, a different shirt, different pants, but the same Converse shoes. That's all seen in the surveillance. He's limping because there's a rifle down his pants. The surveillance captures this individual. Again, I don't want to overstate the evidence because the pictures of his face at this time are not as definitive as they were earlier because of the sunglasses and the hat. But it captures his face, captures his appearance, his height, his build, all consistent with how he looks earlier in the day and how he looks today in court. But he makes his way to the rooftop, makes his way to the sniper's perch on the rooftop, takes the shot, and then runs to the northeast, drops off the building and runs to the northeast of campus into a wooded area. That's all captured on video. Okay, that's the first category of evidence, is the video surveillance that shows the defendant on campus taking the shot. The second point is circumstantial evidence tying him to the rifle. Right in that wooded area, police find the rifle. In the rifle is wrapped in a towel. In the rifle, they found 4 rounds, and these are 30-06 Remington rounds that one has been fired, 3 have not, consistent with the shot at Charlie Kirk. And all of these rounds are unique in that they have inscriptions on the brass. There's etchings on the brass with little political messages. Well, after the defendant turns himself in, there's a search warrant that's executed on his house. In that house, police find a Dremel tool, and they also find the same make and model of ammunition, Remington 30-06. And not only that, but one of these rounds has etching on it, consistent with the etchings on the rounds found in the rifle, right? The etching found at his house says test shot, right? So that's the second category of evidence, is the circumstantial evidence tying him to the murder weapon. The third category of evidence is confessions. The state will present evidence that he left a handwritten note at his apartment for his lover to find. In that note, he says, I had the opportunity to take out Charlie Cook and I took it, right? This note was written before he left St. George and came to Orem and was left in his apartment. His roommate finds it, roommate/lover finds it. And this initiates a text message conversation back and forth between the lover and the defendant, where the defendant says, yeah, I shot Charlie Kirk. And I'm summarizing, shot Charlie Kirk. I left the rifle behind. I had to leave the rifle behind, but I'm going to pick it up and then I'm coming home. Then he also confesses to a group of friends on a messaging application. Before he turns himself in, he says, hey guys, it was me. I did it. Thanks for all the good times. Goodbye. And the final confession is an acquaintance is a former law enforcement officer, and he helps arrange the defendant turning himself into the sheriff's office. And when he's talking to that former law enforcement officer, he says, I got rid of the clothing I wore. Right? So there are 3 categories of evidence that have nothing to do, that show probable cause, have nothing to do with the DNA evidence, which is what defendant's issue is here. The 4th category of evidence is that DNA evidence. And you have to understand what that DNA evidence is. The towel that the rifle was found wrapped in was sent to the FBI lab for testing. There was also a screwdriver found on the sniper's perch that was also sent to the FBI lab for testing. The rifle itself was sent to a different lab, the ATF lab, for DNA testing. And both labs tested those materials completely independently of each other, different analysts, different labs, different locations. Both of them come back showing the defendant's DNA on those materials. Okay, the screwdriver, the towel, and the gun. I say they found the defendant's DNA on those materials. The experts and the reports that we'll present at the preliminary hearing were much more precise than that, right? Really what they say is there's astronomical odds that this DNA belongs to anyone but the defendant. But you'll see that, and I think you take my meaning here. The point is that there is substantial evidence of probable cause, far exceeding what probable cause requires. And it comes from a variety of sources. And so the defendant cannot show that the material he wants to present at the preliminary hearing would defeat probable cause. And in his reply, he says, well, that's circular, because how could we make that showing if we don't have the underlying data to be able to attack the DNA evidence? Well, first of all, that attack wouldn't even affect those first three categories of evidence, right? The confession, the circumstantial evidence tying the defendant to the rifle, or the video evidence, right? But even if they were to find some expert that would say both labs independently got this wrong, and even if they're to find that kind of expert, which I think is speculation and probably against the grain, but regardless, you take that assumption, it still wouldn't defeat probable cause, because at this stage, the court doesn't weigh contrary evidence, right? The standards are very clear. At this stage, because it's such an early stage with such a limited purpose, the court views all evidence in the light most favorable to the state, right? That's State v. Virgin. So in summary, the defense has not shown that the motion to continue is based on the purpose of the hearing, a fair determination of probable cause. They just haven't shown it, and they haven't even tried. And I think one of the reasons they haven't tried is because they know that these are experienced practitioners. They know what the standard is here. It's low. The evidence is viewed in the light most favorable to the state. They're not going to be able to defeat a confession, multiple confessions nonetheless, or DNA evidence, right? And if the continuance was granted, it would affect the victim's right to a speedy trial. And frankly, like the Lopez case, it would obviate the repeated and express admissibility of reliable hearsay at preliminary hearings. And that leads me to the second point, which is a textual analysis. So the defense says, well, Article 1, Section 12, Rule 16 require expert discovery before the preliminary hearing. Let me try to see if my computer will present again.
It's not out for the video.
Let's see. I'm showing it's connected. Oh, here we go. Great. Okay. So let's look at the text of the rules, right? Utah Constitution, right? Here it is. Article 1, Section 12. Where the defendant is otherwise entitled to preliminary examination, the function of that examination is limited, right, to one purpose, as I said earlier, to determining probable cause. Nothing in this Constitution shall preclude the use of reliable hearsay evidence as defined by statute or rule, in whole or in part, right? In any preliminary examination to determine probable cause, if appropriate discovery is allowed as defined by statute or rule. Is it allowed? Well, Rule 16 allows it. That's the end of the inquiry. Well, the defense says, well, no, but it has to be complied with, and that's fair, I guess. So let's look at Rule 16. So here's what Rule 16 says. Look at the mandatory disclosures, and there's a distinction here that I think is important. One is the use of the language here, prosecution team. When we talk about mandatory disclosures under A1, we're talking about what the prosecution team has, right? Prosecution team has been interpreted in case law to mean the prosecutor as well as the law enforcement people who are working on this case. But if you go down to the timing of mandatory disclosures, it's different language that's used here, right? And I've highlighted the portion that applies here. 8, there it says, in every case, all material or information listed under paragraph A1 that is presently and reasonably available to the prosecutor must be disclosed before the preliminary examination. Okay, the different language is the prosecutor versus prosecution team. Had the Supreme Court Rules Committee, and as approved by the Supreme Court, had they wanted this to mean full discovery of everything in everyone's possession before the preliminary hearing, they would have said so, right? The rules of statutory construction say you presume all omissions are intentional, right? They use distinct language here, and they did it for a reason. The reason is because the preliminary hearing is such an early stage of the proceedings, right? We all know investigation at the preliminary hearing stage is continuing. We all know the state, the prosecutors are still getting material from the investigative agencies. We know investigative agencies have processes for getting reports and approving reports and disseminating reports. We know expert witnesses, oftentimes by the preliminary hearing, haven't even started their work, right? The rules, Rule 7B says the preliminary hearing has to take place within 14 days where it's requested, right? This is a very early stage of the proceeding designed to protect the defendant from having to sit in custody where there's no showing of probable cause. And the rule itself, Rule 16, makes clear that discovery is ongoing. It foresees the discovery is going to be ongoing throughout the trial. So the defense argument that Rule 16 requires full discovery of this material before the preliminary hearing is a contra-textual reading. But even so, you look under A1, and what does A1 actually require as mandatory disclosures? Well, there's a specific provision that talks about scientific tests and experience. It's A1B, reports and results of any physical or mental examination, of any identification procedure, and of any scientific test or experiment. We provided those reports, okay? What the defense wants is complete and total expert notice and expert discovery. We've even complied with A1 as it relates to what the prosecution team has with regard to the reports. Okay, so Article 1, Section 12 doesn't require.
For those of you just coming in, this is the prosecution arguing against why the preliminary hearing should be delayed, or should not be delayed. This is all so screwy. I mean, honestly, this is what, September, 8 months now after this happened, and we still haven't had a preliminary hearing. The TLDR is the prosecution doesn't want it delayed because it's only a probable cause hearing, and you don't need every single ounce of discovery per the Utah Constitution and everything else they're citing to get it delayed. Whereas the defense is like, we don't have all the discovery, we need it delayed. I see why the defense wants it delayed. However, now that I'm thinking and processing this more and more, I have not ever seen a probable cause hearing where all the discovery has turned over. Anthony Shea, for one, they're still doing discovery requests and all this. His probable cause hearing was a year ago. Sarah Boone, her probable cause hearing was in 2022. Her trial wasn't until 2024. Like, and she was bitching about discovery literally until the day before her trial. This is odd. This is really odd. And now that I'm thinking about it more and processing it more, it made sense to me what the defense was saying. But now as I'm thinking about it more and more and comparing it to other trials, yes, this is Charlie Kirk. However, at the end of the day, this is just a state murder case. This is not a federal case. This is just a state murder case. And it should be handled, though, differently than any other state murder case. And why they want to delay a probable cause hearing, now I'm on the side of the prosecution. Hold.
Discovery before the preliminary hearing. Rule 16 doesn't require full, complete discovery before the preliminary hearing. Well, is there any other provision of authority we should be looking at here?
I will be
How
right
about
back.
the provision of authority that is directly on point with regard to expert notice? Let's take a look at that. 77-17-13. 1A. If the prosecution or the defense intends to call any expert to testify in a felony case at trial or at any hearing, excluding a preliminary hearing held pursuant to Rule 7, the party intending to call the expert shall give expert notice, right? It's hard for the defense to make an argument that expert notice is required before the preliminary hearing when that's not even an against the grain reading. That's a completely contrary reading to the statute directly on point. The court would have to find that this section does not apply, and it's just impossible to do that. Well, the defense may say, well, we're not requiring expert notice. What we're asking for is just discovery here. Well, no, what they're asking for is in fact expert notice. Rule 77-1713 talks about what expert notice is. If you look at B, right, it's a CV of the expert, the report, written explanation, and then 2 says an expert's anticipated, if it's based on specialized data, the witness shall provide the opposing party the information of that specialized data upon request. Well, the expert notice request, let's see if I can find my list here. Let me give you a list of what the defense requested in their March 25th request. And I should mention, the defense is right. This was not the first time they asked for this material, but when they asked for this material, this specialized data underlining the report, I responded by saying, look, I don't know exactly what you want. You know, you talked about like certain software files and stuff like that. Will you please put it in writing so I don't lose what you want in the translation? And so they did. So on March 25th, they gave me this supplemental discovery request, and that's what I've relayed to the agencies. But what they want is lab case files that the government intends to use in its case in chief. I should note that the FBI has provided a lot of this material already. I provided a case file that's 380 pages long. I think they're back in October, as well as about 77 other files that list their policies and procedures. And those are listed in that 225-page document that I attached in my April 3rd filing. But they list CVs of analysts, accreditation documentation of the labs, accreditation documentation of the programs used to interpret data, standard operating procedures and protocols, STR databases and frequency tables, chain of custody documentation, data files underlying the analysis, software names and software versions used, developmental validation of instruments and processes, internal validation of instruments and processes, proficiency tests of analysts, audit records. All of that material may go to expert qualification, the qualification of the labs, the methodologies, may go to 7.
Okay, Dad, call your son-in-law. Call your son-in-law. That's all I gotta say. Call your son-in-law. He's not home. He left again. He's driving back to a dealership. Call your son-in-law. Call your son-in-law. I'm gonna need to grift because we might have a truck payment.
102 issues, but it doesn't go to probable cause. Okay, especially when you've got to view this evidence in the light most favorable to the state. And the final reason why we know that expert discovery, expert notice is not, I didn't finish my point here, which is this material they're requesting is expert notice. Like that's what they're requesting here is expert notice under 77-1713, which expressly does not have to be given before the preliminary hearing. And I should say, regardless of the fact that we're not required to give expert notice before the preliminary hearing, we're doing our very darndest to do so. And we shouldn't be penalized for being on the ball and getting ahead of things by trying to get the expert reports and investigation done as soon as we can. To the contrary, we should that's the kind of behavior and due diligence that should be encouraged and incentivized. And if you say, no, you can't have a preliminary hearing until all of that is done, it does create chaos in the system, because it says, if I want to have a preliminary hearing early, I'm going to stop my investigation once I hit probable cause, because then I don't have these discovery problems before the preliminary hearing. And that is not the type of conduct we want to incentivize. And the rule doesn't incentivize that conduct. And this comes to my final point. The defense knows it. Okay. I know that Mr. Novak has made his argument here, but the defense knows that this kind of material is not required before the preliminary hearing. And how do we know the defense knows it? Because the defense has said so. In one of their earliest pleadings in this case, docket number 16, I think it's 16, the defense counsel filed their request for discovery. This is the formal request for discovery that's filed, I think, docket 16. And in that docket, they recognize the discovery is an ongoing process. Get down to page 11, and the defense cites Rule 16 saying, the prosecutor's duty to disclose material is ongoing. In every case, all material that is presently and reasonably available to the prosecutor must be disclosed before the preliminary examination, right? But here's the key phrase that I think shuts the door on this argument the defense has made, is highlighted in red there. And I quote, defendant acknowledges he does not have a right to discovery prior to preliminary hearing pursuant to Article 1, Section 12 of the Utah State Constitution.
Oh, damn. Oh, damn. Oh, damn. Sorry. Okay, now I really see, now I'm really on the prosecution side, because they literally said in a motion, and I was looking at the documents, it does not look like it's 16, but that's beside the point. It's request for discovery at 61. The prosecutor is dyslexic. It's 61, request for discovery, 9/30/2025. But it's, when you say in there that you don't need all of discovery, or you aren't privy or entitled to all of discovery before the preliminary hearing, you just shot yourself in the foot with this. Here you go. You need that more than I do in Minecraft, because you just used it. You just argued. It's like we discussed on Members Mondays, and one of the classes was how not to argue against yourself. You argued against yourself. Now, that was kind of the icing on the cake for me.
That's it. The defense concedes this point. Now, the point I'm making is what the defense makes right here in the next sentence. However, defendant relies upon this initial discovery request through trial, post-preliminary hearing, to enforce their rights encompassed in the Utah Constitution to a fair, speedy trial. That's the point I'm making, is the state should be pursuing expert investigation, their due diligence, getting the investigation done as early as possible, and providing that discovery as it comes in on a rolling basis, right? And that's what we want to have happen. We shouldn't punish the state and the victims and everyone else by delaying the proceedings when the state does exactly what has been done here, which is getting on top of those things early, right? I think that's all I have, Your Honor. Do you have any questions for me?
I will. I'm going to turn to defense for their rebuttal and then have questions for both parties. Thank you, Mr.
Oh, that should be an interesting rebuttal now. We didn't really say that. That's how to use your own words against you. Come on, Novak. What you got, bro? How is he going to argue against that? Like, really?
I do want to respond directly to a number of the arguments that Mr. McBride made.
This right here.
I want to refer the court back
This right here.
to
OB 711, you make an excellent point. This is why motions and responses should be as short as possible. Only include as absolutely necessary. I don't know what it is. I had a realization the other night when watching the expert stream, and The expert was watching a montage of people responding to a doctor's testimony in the Karen Reed trial, and it was all lawyers who were like, oh, she's great. I agree, this doctor was great. But it was like a realization of the difference between a medical background and education and a lawyer's education. We say things as quickly as possible, as succinct as possible, as layman's terms as possible. Patient did this for this for this. A lawyer will put something that a medical professional, whether it be doctor, therapist, nurse, nursing assistant, CMA, whatever, doesn't matter. We are taught to write as little as possible because whatever you say, if you didn't write it down, it didn't happen. But if you write too much, it could be used against you. You only write what you have to. But you're also writing on limited time. We only have so much time per patient. And the more you write, the less time you get with the patient. Lawyers are opposite. We're also taught how to talk to people. Lawyers seem to be the exact opposite. You get so much book smarts that you lose like writing things in a timely manner, in a succinct manner, explaining easily. And it's like, it was a realization that smacked me in the face of why lawyers annoy me. Like, it just, it's, you know, Squid, you heard of the lady that tried to kidnap a child at Walmart and her family and took the kid and stabbed him and left right in the top of the head. Yeah, I have heard of that. I'm going to look into that more and more, because parents who shouldn't be, or people who or do things to kids and parents, just kidding. You'd think I'd dare send something direct. You always send me stuff direct. I take it you called your son-in-law. I take it you called your son-in-law. Wow. Yes, you told him that he should get a new truck. And now, yeah, well, yep. This is your fault, Dad. This is your fault.
The accused.
No, he did ask my permission.
Initiated this case, which is the
I was
information.
getting a new truck.
The information specifically relies upon two types of DNA evidence. First, the information, and it's actually the probable cause statement in the information, docket number 1. At the bottom of page 3, the probable cause statement alleges that DNA consistent with Robinson was found on the rifle's trigger. Second, the probable cause statement in support of the information says in the middle of page 6, the rifle, ammunition rounds, and towel were sent for forensic processing. DNA consistent with Robinson's was found on the trigger, other parts of the rifle, the fired cartridge casing, 2 of the 3 unfired cartridges, and the towel. We have not received the discovery, and I'm not talking about expert notice, I will address that. We have not received the physical evidence and the electronic evidence that supports those assertions made by Mr. Gray when he swore to the probable cause statement attached to the information. We are not talking about the broad scope of expert notice, of expert discovery that Mr. McBride is talking about. We're talking about physical and electronic evidence, which first, the information was based upon, as I just said. And then second of all, as Mr. McBride acknowledges, the state intends to present the limited DNA evidence that it has without even having the data files been made available to.
Yes, to establish probable cause, not to convict. Big difference. Establish probable cause, which is what a preliminary hearing is for. So your rebuttal is just, now his rebuttal is just whiny to me now.
To us. And I want to drill down on this very specifically because I think it's appropriate, but the state sent us, but did not file with the court, a memo outlining the witnesses they intend to call at the preliminary hearing and the exhibits that they intend to offer at the preliminary hearing. And I'm going to respect that it's their present plans, and it's not something that necessarily should be filed under seal, filed publicly. But as Mr. McBride acknowledges, that includes 3 DNA reports. We have those reports. We just don't have the data that the authors of the reports relied upon for those conclusions. And I'm not talking about their CVs. I'm not talking about their published writings. I'm not talking about their prior testimony. I'm not even talking about all of the things that Mr. McBride acknowledges we've asked for and that there may be a fight about later in terms of discoverability under Daubert, under 702. We're talking about a core data file. It's literally a data file, one from the ATF and one from the FBI that they generated back in September that hasn't been provided to us. So we can't provide that to our experts to help us assess whether or not there are reliability problems with the reports that the state wants to offer through 1102B4. So we're not talking about the slippery slope and months of litigation of Daubert type expert notice. Mr. McBride is right that at a certain time and place, there will be discovery litigation related to experts and then admissibility litigation related to experts. That's not what we're talking about here. We're talking about very concrete data files that our experts are waiting for. And when I say data files, I literally mean the digitization of physical evidence obtained from our client and from these objects. We didn't choose for the state to present DNA evidence at the prelim. That's their choice. And that's why we are having this dispute right now. The question that I think this court needs to also address is when Mr. McBride talks about what discovery is, quote, reasonably available to the prosecution. How can this court conclude that not having these data files is reasonable, given that the ATF and the FBI generated these data files from the swabs months ago? They've concluded their work, as far as we know. They've generated reports. The state believes that the reports are sufficiently final that they would offer them into evidence in a preliminary hearing. So I think this court should make the finding that those reports are reasonably available and that they should be produced to us. Mr. McBride, probably because he can't, still hasn't told the court why we don't have the data files. So where Mr. McBride, with all due respect to his advocacy, because he's a fantastic advocate, goes, is he goes into the slippery slope of expert discovery and expert notice and Daubert, and that's really not what we're talking about here. We're also not talking about the bullet fragment further testing issue, which has previously been described as the January 9th motion, which the court unsealed. That is not a DNA issue. That is about what happens to a bullet fragment when a federal law enforcement lab wants to do what they call destructive testing. It's not to get DNA off of it. It's to look at whether that bullet fragment can be related to the other evidence in the case, because the ATF's first conclusion, as the court knows, is that they couldn't say either way where that bullet fragment came from in terms of firearms. So that is not what we're talking about here. There is a ballistics report that the state wants to offer into evidence at the prelim, but we're talking about DNA reports. And I do want to say, however, that we are
You're
not suggesting that the preliminary hearing,
You're not having an evidentiary hearing or a Daubert hearing where you're trying to figure out whether these things are going to be admissible at trial, not the time or the place. The state is offering enough evidence to establish probable cause. They're not getting into all of the ins and outs and details and scrutinizing that evidence down to the microscopic level. They are establishing probable cause. We're way overthinking this, and I understand that it's a lawyer's job to analyze things, but it just seems like they're making this way more complicated than it has to be. And I have a theory. Y'all feel free to disagree with me on this, and I will put down in the comments what you guys think. But I have a theory what this defense is doing, and I don't like it. This defense, in my opinion, is taking advantage of the fact that a lot of people are paying attention to this trial and all of these hearings who have never watched a trial in their life. They don't know what a Daubert hearing is if you gave them $1 million. They don't know what an evidentiary hearing is. They don't know what probable cause even means. These are people who don't know how the law works. They don't know what the normal course and flow of a trial is. They've never trial watched. They've never been on a jury. You have a bunch of people who are literally watching trials for the first time. And you have this defense team acting like all these things are supposed to happen right away because the public wants all these things to happen right away. You have people on one side of the aisle who are like, this kid didn't do it, that he's being framed by all these people, blah, blah, blah. Show us all the evidence if he really did it. When all the evidence will come out at evidentiary hearings and trials. You will not get the metadata for the text messages today. You will get that at trial because that's where that's appropriate to be shown to a jury at trial. Then you have people on the other side of the aisle who are so adamant that Tyler Robinson did it that they want all the evidence shown to prove they're right. And they've never watched a trial either. And they're like, we want it now, we want it now, we want it now. And that's not how the legal system works. I have a theory that this defense team is taking advantage of everything that is wrong with society right now, and that you have a bunch of uninformed people who are talking heads on the internet who think they know what the hell they're talking about and really don't. I know a little bit. I don't know everything, but I fully admit I don't know everything. Not a lawyer, but I have watched enough trials to know that certain things will not come in right now. Certain things will not ever be allowed. The jury will never, ever be allowed to see that we know. This defense team is taking advantage of the public's interest and trying to get the public on their side as to the judge sucks because he's not letting this in. The prosecution sucks because they're trying to rush the process. They're taking advantage of a whole bunch of people and public outrage where it's not even the way it works. It's just not even the way it works. And it just kind of hit me right now. I was on the defense team side, and then the more they started talking and the more they explained themselves, the less I agreed with them. Sometimes less is more. More is not always more. Like a teenager in makeup. More is not more. That's why he's talking about DNA. He wants an expert to compare the analysis to determine if their expert can rebut it. And it's not the time and the place. Yeah, and I believe it's Novak. I'm going to Google it right now, but I believe it's Novak who was the defense attorney for the Menendez brothers, which says a lot about his trial experience, for better or for worse. Yeah, they're basically claiming that they're not getting the discovery when discovery isn't yet required. Yeah. It's and I'm like, I could be completely wrong because I'm not in their head, but just from someone who's watched trials for about 4 years now, 2 years on YouTube, and I don't sit down and watch trials, stream trials as much as I want to because 3-year-old just don't have the time. However, this is not, they're rushing the process. They're putting the cart before the horse, hoping that public outrage will be on their side because you have a bunch of people who don't know how the legal system works, who are commenting on the legal system. It's just, yeah, I agree with you. I've watched many trials. This is not like most trials go. Yeah, and I was kind of on their side at first, like, hey, yeah, I agree, push it back. And then the more they started talking, it just rubs me the wrong way.
Be postponed until this dispute about the destructive testing of this bullet fragment is resolved. But it was a federal law enforcement lab that said, we're not going to permit a defense expert to observe the destructive testing, and we're not going to videotape the destructive testing. We're going to do this behind closed doors. But that's not what we're talking about here today. That's a different issue for a different time. And I don't think it has anything to do with when the preliminary hearing occurs.
Do they just want to delay?
Mr. Novak, just to be
Also, do they just want to delay their client actually putting in a plea? Another just random question. Do they want to delay their client putting in a plea?
consistent, do you have some final thoughts as your time is coming to a close?
Yes, thank you. My final thought is that this court should direct the state attorneys to find out when the data files will be produced. And once we know that date and they actually are produced, then we've already told the court that there's a concrete amount of time that our experts need in order to analyze them. Otherwise, I've already argued about the constitutional and legal principles that are at stake here, and I think that the court has those in mind. I also want to say, finally, the Lopez case has nothing to do with this. I understand it's a Supreme Court decision, but the Lopez case is about a defendant who tried to serve a subpoena on the victim of a sex offense to have the victim testify at the defendant's prelim. That is not what this is about. We're not fighting about a subpoena. We're not talking about victim testimony. It's really not applicable. Thank you, Your Honor.
All right. Well, I'll have questions for both of you. I'll start with Mr. Novak. Again, thank you both for your presentations today in such a succinct manner. The court appreciates that. So one of the questions that's before the court, and Mr. Novak, it goes to the heart of the matter for this court as the court is weighing whether the continuance should be granted or not. Has defense reviewed all the discovery that has been presented up until this point in preparation for a preliminary hearing set for next month?
We have reviewed the discovery that is tied to the exhibits that the state intends to offer at the prelim where there is discovery available. If the court is saying, have you reviewed the thousands that have the lawyers reviewed the thousands and thousands and thousands of pages of discovery that are well documented in the index that Mr. McBride provided the court privately? The answer is no. Our paralegals are doing their best to organize it, but have counsel reviewed that discovery and have we had a reasonable time to do so? No, because it's gigantic and it's voluminous. We know that some of it has nothing, some of it it has been provided in what I guess the state would call an abundance of caution, 30 days worth of surveillance video from UVU. We don't believe that we even need to review 29 of the 30 days. So we're not going to waste time and resources reviewing hundreds of surveillance camera hours without some suggestion that we need to. And we don't believe that we do. Have we reviewed, every FBI report interviewing people who claim to have known Mr. Robinson or known his roommate? Yeah, we've reviewed all of that. Have we reviewed the forensic materials that we have received? Yes. Have we reviewed all the law enforcement reports about the events at UVU? I mean, I can only speak for myself. No. Because it's so voluminous that we haven't had that time.
Well, in really the heart of my question is, have you reviewed all the discovery that has been passed that enables you to be prepared for a prelim next month? That's that you're saying is applicable to what you understand the state will be presenting, or what you need to review. Just because the state says they're going this direction, you have to do an independent determination of the discovery on what you need to review to be prepared. And so my question is, have you done that, and are you there?
No. So for example, we received a couple of months ago an external hard drive that had thousands and thousands of gigabytes, I don't even know how many, of material taken from digital devices, taken from search warrant returns from what I'll refer to as social media communication platforms, Discord and all of the others. No, I haven't had time to do that. Absolutely not. My client.
FYI, this lawyer charges $500 to $600 an hour. Just FYI.
Clients, so there's a huge download of my client's cell phone. There are downloads of many digital devices. No, absolutely not.
But my question is, in order for you to be prepared, you've made the argument there's a lot, and there's no dispute that there's a lot of discovery, to say the least. But you've also said that you don't need to review it all. You just want to review what's relevant for the preliminary hearing. And so my question goes to, have you reviewed all the relevant discovery that's been passed to be prepared for a preliminary hearing that you have in your possession now?
He's trying so hard. He's trying so hard to deflect, because the judge is asking the same question 3 different ways. And you can see the judge's forehead lines starting to get bad. Like, I'm putting some of this on my forehead now because my lines are getting bad. But you can see the judge is being like, look at this expression. The judge is starting to be exasperated with this bro, because I'm sorry. Dude, just answer the question. You're a lawyer. Answer the judge should be like, I asked a yes or no question. I want a yes or no answer. It's my favorite response when they try to give me stuff. It's my lawyer answer. I asked a yes or no question. I want a yes or no answer.
I can only speak for myself. I'm not going to speak for other counsel, but the answer is no. The answer is no. But I am not able to, maybe this isn't the court's question, but I'm not even able to approach this 4th category of evidence that the state wants to offer at the prelim, which is the DNA evidence, because we don't have the underlying.
Stop bringing up the DNA. The DNA is being brought up as probable cause. You're not having to fight to exclude it. It's probable cause. You are a lawyer. Do you need the definition from Cornell's Law School for lay people on probable cause? Because probable cause, you don't need detailed, minute, down to the microscopic level. You need probable cause. Oh, this is why I hate lawyers, because he's sitting here trying to argue the same point 6 different ways, and the judge. This is why I could never be a judge. I could never be a lawyer, because I'd be like, you stupid, get out of my face.
Data files to be able to assess what to do about those reports. So if the court said to me, Mr. Novak, have you reviewed all the drone images that they want to use? Have you reviewed all of the video that they want to present? Have you reviewed all of the UVU surveillance? And by the way, this is a letter we received on April 4th. Have you reviewed all the Discord chats that they want to present? No.
It's probable
And
cause.
I believe I've been diligent.
Would you like time to confer with your counsel? Because I need to know that information. I need to know that if we move forward with the preliminary hearing, either next month or a different date, that that there's effective assistance of counsel moving forward. And that's one of the
They're all gonna
factors
say
is,
no.
have you reviewed the necessary discovery? Typically in criminal cases, the defense attorneys say, hey, I haven't been able to for whatever reason. And the court recognizes that, right? Like I get it, but I need to check that box and say, okay, defense is saying we're ready to go forward with the discovery that has been provided. That's a part I want to be sure is been accomplished. And so as you're presenting for the defense, I would ask you to confer with your counsel, because I understand that you've probably parsed out different areas for each counsel given what's there, but I need that answer as it relates to the defense team.
I now understand the import of the court's question, and I appreciate that the court has clarified that. So we can present that information verbally. We can present it shortly thereafter in writing, however the court wants to present it. But I understand that. So I'll just give the court by way of an example. I have not personally, and I don't think any of the other counsel have, but we should probably take a short break and we can discuss that. Reviewed
You should take a long walk off a short pier.
significant portions of the electronic discovery. And when I say electronic discovery, I mean images of device downloads, as well as, sort of cloud-based information produced to the state pursuant to subpoenas for chats, postings, gaming communications. I mean, the primary platform is Discord with a capital D. It's a thing,
Sure.
right?
With somebody clip that with a capital D. Damn. Speaking of Discord, if you would like to join mine, oh my God, I do have a Discord server. It is not as nearly as entertaining as what this Discord server might have been. It is boring. We talk recipes and workouts and all of that, but that is my Discord server. If you would like to join it, we're boring, but we're a good group. But Discord with a capital D. Sorry, I don't know why that broke me, but it did.
So I think I'm just repeating myself, and maybe that's because obviously I would want to speak with my
Sure.
co-counsel and
No,
not speak for them.
I respect that. I understand that you're being cautious and you don't want to present something that someone may or may not have reviewed. So I respect that, and you'll be given time to do that. But that's an important factor for the court to determine.
Totally understand. I mean, we've been trying to focus on the very specific items of discovery that we don't have, which relate directly to evidence that the state wants to present at the prelim. And the court is asking, I think, very helpfully, a broader question. And the court is not challenging, the court is not really confronting us on the question of diligence, so I'm not even going to go there. But obviously, there's been a lot of pretrial litigation on a lot of different issues. And as the court knows from our filing yesterday, there's more coming.
Right. No, and I appreciate that. And the court's intent is I just want to make sure that when we move forward, we can move forward properly and uphold the constitutional rights of Mr. Robinson and all parties to ensure that what we do is proper and appropriate, because quite honestly, I don't want to do it again. And so, I recognize, and I can do so, that both sides have been very diligent and have worked extremely hard. Obviously, I'm not in your offices. I don't know your communications, but it is evident to me that both sides have. And so the purpose of that question is, that's just a checkbox I need to know to move to that stage. And only your team has that answer. And again, and I recognize the amount of discovery that's been is out there. And so it is no way to impugn defense at all, saying, well, you're not doing your job, you're not working hard. Not at all. I just want to know that answer. And so that's
I
the sole
appreciate that.
purpose.
And I didn't feel that the court was making those assertions. And I want to say, we hear that the court doesn't want to do it again. Mr. Robinson and his family don't want to do it again. Counsel don't want to do it again. We know that the state doesn't want to do it again. And we also don't want Mrs. Kirk and her family to have to go through it again, because that's actually, in my opinion, the greatest harm to surviving victims in a case like this is the long run when cases don't proceed as the Constitution requires.
And so going to that point that you just asked, so how do you propose the court balance your request for a potentially large, a long delay against the constitutional rights of victim representative Ms. Kirk in her right to a speedy disposition of the case? For example, I noted in your motion, you stated that your DNA expert needs, I believe it was 6 months.
That was her estimate.
And so how do we balance that? And I appreciate your statement, but going to your statement as it relates to Ms. Kirk's right to a speedy disposition of a party outside, right? Not counsel from either side, but it seems like we're going to be held to the timeline of somebody outside who's an expert who's saying 6 months. And that concerns the court about that is a potential hang up of, well, we can't move forward until we comport with their timeline. And that's concerning. So how do we reconcile that?
Well, first of all, if the expert needs 6 months, the data files were available in September, which was 6 months ago. And so I actually think, while I will answer the court's question, another important question is, why haven't the FBI and the ATF provided data files that they utilized 6 months ago? And Your Honor can't answer that question, and I can't answer that question, and obviously Mr. McBride can't answer that question. And so I actually think, and I don't purport to speak for the victim representative, but that's a question that the victim representative should be asking, at least through her counsel, is why haven't the federal law enforcement agencies, which took responsibility for this analysis, provided the data? Not the CVs. I mean, I've actually examined at least one of these FBI forensic examiners in another case. I have her CV. That's not my issue. We cited in our reply brief the cases which show that the victim's right to a speedy trial does not, I'm sorry to use this word in the current environment, but that's the word we use, does not trump, lowercase t, the defendant's constitutional rights.
Oh my God.
We do not want.
Oh my God. Oh my God. Oh my God. Tell me he's from California without telling me. Jesus, Pete. Like, if you have a hard time putting the word Trump in a sentence because you're worried it's going to trigger people because of the president, my freaking Lord, bless your freaking hearts, because, oh my God, I'm going to pray for you because the TDS is real. Like, if you have a problem with using Trump in a sentence, like, this doesn't trump the evidence, and you're worried that people are going to take that as you're talking about you. He just said that. He just said that in court. That look on the judge's face. Like, I don't care. Shut the hell up. It's like, tell me you're from California without telling me. And no offense to the people who are in California. Most of you are great people, but some of y'all in like the LA, San Francisco area are like, huh? Do y'all just wake up and look for something to be angry about every day? Because, yeah, he probably found this picture. Somebody please play euchre with this guy. Oh my goodness. Oh, Sheep's head just ain't his thing. Like,
The victim representative and her family to
Oh.
have to wait any longer than we have to wait.
And I'm
But-
totally fine with if you don't like the president, if you like the president, I don't care. But like, if you are so triggered that you can't use the word in a sentence, that's a problem. That's an internal have a blessed day kind of issue.
It isn't sufficient for the state to say, we've turned over gigabytes and gigabytes and the defense, doesn't really need to review it before the prelim. That's not, obviously, in the court, I think, tends to agree with what I just said, that doesn't make a lot of sense. So we do respect the concerns of the victim representative and her family, but we can't constitutionally shortcut Mr. Robinson's right to the adequate assistance of counsel. And I think, as we said in our brief, when the state doesn't give us the data that their law enforcement partners have and have had for 6 months,
Yep, blame it on the
we
state.
can't be constitutionally effective. And, and again, I keep talking about Mr. McBride because I appreciate his advocacy, but if the state didn't want to have to deal with Article 1, Section 12, the concept of appropriate discovery, this court's need to apply constitutional standards of reliability, Mr. Gray could have presented this case to a grand jury. And instead, what Mr. Gray did was he filed an information with probable cause that relies on multiple assertions of DNA results. We should have had that discovery under a different rule immediately. If he had reports that are based on these data files, when he filed his information and probable cause, those data files existed. Those data files must have existed on September 15th or whatever the date of the information was. And here we are past April 15th. So I will confer with my colleagues on the court's question. We will obviously answer it because it's an important question. If the court has other questions for me,
I do. And
I'm
so
prepared.
going to the state's argument that there's these 4 prongs that can be pursued in regards to the categories of evidence, and that the standard is clearly articulated in State v. Virgin, and so my question for you is, if the state's presenting evidence that can meet the standard in any of the 4 prongs, is it necessary that all the discovery for all the prongs be turned over in order for the defense to be ready to proceed at the prelim?
Ding, ding,
I'm
ding,
not
ding,
gonna
ding.
speculate
We have a winner.
about how the state's presentation at a preliminary hearing would go as to prongs 1, 2, and 3, nor could I concede that without seeing the way the witnesses testify and which reports are actually received into evidence that they establish probable cause. It's the state that wants to present DNA evidence through summary reports, not through the witnesses who wrote the reports, not through their own state lab analysts. So it's not for me to comment on categories 1, 2, and 3. I understand what Mr. McBride is representing, but I can't comment on what this court will think of that evidence. But it's the state's decision to present 3 different DNA
Speed him up.
reports, at least at the current time, according to the memo that they gave us earlier this month.
Okay, just say
And
that they
to their
can't
federal
produce.
law enforcement partners who have not complied with that reasonableness test. And that's got to be imputed to the prosecution because we don't have it. Nobody's accusing anybody seated at council table or over there of stalling out anything.
The only one
And,
stalling is you. We've been
I
here
think
for
the court
almost
deserves to
2
know
freaking hours.
why the FBI and the ATF haven't turned over these data files.
Well, I mean, I understand, but that doesn't get us to where we are today. The why doesn't help us right now.
Well, then
because-
why might tell us when. I mean, your Honor is absolutely right. The better question is when. And then when we get them and our experts look at them, maybe there is a refined assessment about how long that takes.
So my final, oh, I'm sorry.
No,
keep
no.
going. My
That's all
final
right.
question is I'm trying to avoid a slippery slope of, wait, we need one more thing. We need one more thing. We need one more thing. Are you saying, my understanding is, and I have, I understand to a small degree, given my experience about what you're requesting. You're requesting the lab notes, like all the underlying data that was put in to generate the DNA reports and the findings. Is that my understanding? What you're requesting is that is still outstanding?
What is actually outstanding is, yes, but most importantly, the data, the electronic quantification, digitization.
In his defense, these are questions from the judge. These don't go for his 30 minutes. His 30 minutes was for his argument and the rebuttal.
Of physical evidence taken from our client and certain objects that leads these forensic examiners to conclude that there are matches. Mr. McBride says, oh, there's two different things, and so they're both right because they each independently reach the same conclusion, but they're testing different objects in different labs with different protocols. We don't even have those data. And yes, with respect to the court may be asking me a question that is better addressed by Mr. Burt, because he's the one who specifically crafted the discovery request. And I know that Mr. Burt has reviewed more of the DNA forensic discovery than I have, but I can tell the court that without those data files, we can't even start to analyze, to understand, to appreciate the conclusions, the statistical analyses, the results of those tests. So yeah, the bench notes and the protocols that were followed, yeah, that's all important, but we don't even have the data files. And there's no reason that I am aware of that has been provided why the ATF and the FBI, first of all, the ATF, why they provided it in the last 3 weeks, and why the FBI still hasn't. And so I don't think it's going to be a dribble of this and that and this and that. It should have all been produced, some of it 6 months ago, because we have DNA reports from September
Everybody else falling
2025.
asleep with this dude
Mr.
talking
Gray
and
relied
saying
upon
the same
present
shit over and over again.
I guess what I'm trying to do is I want a bright line of saying this is exactly what we're requesting, and it's the court's decision if that's necessary or needed to proceed with a preliminary hearing. I just want it to be so clear that we know, okay, it is, hypothetical. We need a blue pen that is BIC or whatever. That is so definitive there is no question, because what I'm trying to avoid is, well, okay, they provided this, but it's not exactly it. They provided this is not exactly it. And I respect your position. And I understand it. I just want to make sure there's no ambiguity.
Judge,
And
you're
that's
never
why I'm
going to
trying
get that.
to distill this to its finest point, so I know exactly what you're asking. Because when you say data files can be anything. I want it to be clear as day, so nobody can say, well, I didn't realize.
This judge is asking for something he is never going to get from this defense team. This defense team is never going to give him clear-cut answers, because there is no clear-cut answers. These are the type of people, these are the anti-Hales people. These are the people who move the goalpost. Every time they get something, they move the goalpost to make it further. This is not the type of people who say, I want the cell phone data, and then they get the cell phone data and they're fine. These are the people who constantly move the goalpost into what they want. And then we will be here till 2029. And as much as I'd love the content till 2029, no offense, I can come up with other things to talk about. I have shit that I have not covered and that I want to cover because this.
It was that. And you're saying the FBI hasn't turned over the data files. That is a very broad statement. And so I want to make sure we distill it to, it is this exactly. So the prosecution can say, okay, well, if we need to communicate with our their federal partners, then they can, and they can say, this is what we needed. But if it's just a broad, we're missing data files, that's difficult for the court to weigh whether it is actually necessary in order for the preliminary hearing to proceed.
So I think then what the court is maybe requesting or maybe suggesting is that
The
there's
court
gonna be
is
a
requesting
continuum
you
from
not be
what
a douche
data
canoe.
that we need in order to be constitutionally effective at this prelim versus the continuum from that all the way over to what is more in the nature of expert notice 702 Daubert issues before a trial. And as long as the state's position is none of what you're requesting, not even the digitization of the DNA taken from Mr. Robinson and the DNA lifted from these objects, if the state's position is that that's just Daubert discovery, then we can have the conversation with the court and we can give the court our view of where the line is between what is data that should be reasonably available to us now versus what is Daubert. But Mr. McBride's position is we don't even need the digitization of the DNA swabs in order for this preliminary hearing to go forward. So if the court, I'm not trying to obviously put words in the court's mouth,
I'm
but
not trying to
if the court's saying,
delay.
I'm not going to go that far,
I'm
but I
trying
need
to
to draw a
delay.
line somewhere, then we can take our discovery letter, which we gave Mr. McBride, and we can tell the court, these are the things that we think we need in order to be able to go forward in the preliminary hearing, and we acknowledge that these other things are more akin to expert notice, Daubert, and Rule 702 issues. We can do that, and it wouldn't take long, but and I think it's an appropriate way for the court to say, I'm not able to guarantee Mr. Robinson effective assistance of counsel at a preliminary hearing until the defense has the.
I'm sorry. I think Mr. Robinson, as much as I don't like him, has a case for ineffective assistance of counsel just because you're a douche canoe who keeps delaying the inevitable.
These pieces, and the others can wait. So I understand the court's question, but it does require looking at a 3 or 4 page discovery letter and drawing a line somewhere, or maybe it's yes, no, yes, no, yes, no, or you know.
No, but and to be quite blunt, that was the hope of the court for today. You're asking for the continuous because some discovery hasn't been provided, but I want to know what that is in order for the court to weigh that.
Well, we will do that today. We'll do it the moment the court wants to take a break. We can do that,
Okay.
and we can tell the court these are the things that we think that all the different authorities that I've cited require now versus the things that Mr. McBride is saying are expert discovery, and then the court will make its determination of which bucket each of those items goes in.
Sure, I appreciate that.
I think that's fantastic.
All right. Thank you, Mr. Novak. I think I've asked plenty of questions. I want to afford the other side the
Always open to
opportunity
questions, Rob.
to have that same experience. All right.
Ah,
All right. Turning to the state.
Island, you're always welcome here.
All right. So the
I,
defense has emphasized that this is a capital case, which triggers an Eighth Amendment requirement for heightened standard of reliability at all critical stages of the proceeding. How does the state's proposal to proceed with highly technical, uncross-examinable forensic hearsay reports without defense having access to the underlying data, I use that word loosely, satisfy this heightened constitutional requirement and the defendant's Sixth Amendment right to effective assistance of counsel?
Well, my tendency is to say, well, if you require these experts to come in and testify, we're doing the same thing that happened in Lopez, that was rejected by Lopez in obviating the admissibility of reliable hearsay. And I don't think that just because it's a capital case, you throw, the baby out with the bathwater here. The rules are the rules, and they satisfy constitutional muster, and they don't change because it's a capital case. Should we pay special attention to them? Absolutely, we should. And we should keep in mind what's at stake here. But it doesn't mean there's a completely separate set of processes and rules that apply to a capital case, right? It's just that we are very rigorous in the analysis of how we apply those same rules to these facts. So I think reliable hearsay is still admissible, and that's where we are. The rules govern, and the rules clearly don't require expert discovery and expert notice before the preliminary hearing. I don't think there's any way to read the rules to require that.
All right. One of the other issues that's been brought up is defense argues that the FBI and ATF act as your law enforcement partners and therefore are part of the prosecution team. How do you reconcile your position that you only need to provide what is physically present and reasonably available to the prosecutor under Rule 16A2 with the broader definition of the prosecution team? Does the state have an affirmative obligation to compel its federal partners to produce the underlying forensic data for this hearing?
I don't think for this hearing. I think the state does have an obligation, absolutely. I think that obligation, the case law is very clear. That obligation certainly applies by trial, right? We've seen numerous cases reversed because the prosecutor has not gone out and gotten material that's in the possession of a law enforcement officer. Some of that stuff, the prosecution probably couldn't have gotten anyway because it was hidden by police officers, right? But yeah, certainly by trial, the defense is entitled to all this material. I can't say all of it because there's probably going to be some objections to some of the material they've requested, like the source code for some of the proprietary software developed in this case or used in this case. But they're entitled to most of that stuff, and we're going to provide it. And that because that's the basis of 702 hearings and also admissibility under 702 and weight questions at trial. But at the preliminary hearing stage, no, the state does not have the same obligations, the same discovery obligations that apply at trial. Now, that doesn't mean the state can put its head in the sand either. What I think is important under Rule 16 is what is reasonably available to the prosecutor. And that's what we're doing here. The point of my April 3rd filing was to say, Judge, look at our over 20,000 documents or files that we provided to the defense. You can see in there, and we asserted at that time, we provided approximately 100% of the materials that we have, right? And you can see that we're not burying our head in the sand and saying, don't give us anything else, guys. We don't want to know. No, we're saying,
I didn't get my clothes.
stuff
She did
goes over,
hers.
we send it out. And you can see in there the dates that we receive materials and the dates that we push them out. And we're talking within a week, generally speaking, sometimes within days, no longer than probably 2 weeks. We're pushing everything out that we get. And so what is reasonably available to the prosecutor? What does the prosecutor have in his possession? Those are the materials that we've provided, and we've satisfied Rule 16. What we can't do is bury our head in the sand and say, don't give us anything else. And that has not been what's happening here. But neither do the rules require complete expert discovery and discovery of these highly technical data files. And that, your live inquiry with Mr. Novak just a minute ago raises the importance of this. Yes, the defense, I can't tell you the first date that we had a conversation, an oral conversation where they said, hey, we need the data files. And I remember a conversation we had, I can't remember, Mr. Bird, if it was with you or Mr. Novak. And I said, well, look, assume I'm an idiot. I don't understand what data files are. Tell me exactly what you need. And they say, well, we need the software files that can be used in the software program so our experts can run it. Okay, put that in writing so I understand and don't misrepresent what you want. And so when did they put it in writing? March 25th. So once I got it in writing, that's when we started looking through. I looked through my file and analyzed, do we have this stuff? Have we provided it? Help me understand what's going on. And after I did my analysis, I sent it off to the labs and said, hey, I've done my analysis of what I think we've provided here. Will you guys look at this and see what you think you've provided? And then tell me if if you haven't, get it to me. If you're not going to, tell me why. And we had that communication. We had a communication about that this week with both ATF and FBI. And I think a lot of this material they've requested, we have provided it. Some of this material was provided clear back in October, most of it. A 380-page digital case file from the FBI, disclosed October 24th, date stamp 79. CVs of 3 of the analysts from the FBI. There's case notes provided October 24th. That's Bates 122 and Bates 845 to 848. 73 files of policies and protocols, validation, testing procedures, analysis, proficiency procedures provided October 24th and 12 on December 9th. Now, the ATF lab, they were continuing to do investigations, or excuse me, not investigations, but expert scientific work on this case until the end of February. They chose to wait until they finished to compile all of their case files and to get them to us. We're talking thousands of documents. It takes, you don't snap your fingers and have them all together. It takes time to put them together. Once they got them together, they sent them to the SBI for processing, make sure that the detectives, investigators are aware of the materials, and they provide them to us. We bait stamp them and send them out. And those are the materials we received this week. Okay, so there's been no delay here. And we've done what's required under the rule. But I think the important point is to go back to the purpose of the preliminary hearing, because what you're talking about here is, have we completed full expert notice? I mean, I know Mr. Novak says, well, that's not what we request. Well, that's what we understand, and that's what the pleadings seem to request. And this material, these data files, those are materials covered under full expert notice under 77, 17, 13, not under Rule 16, and certainly not under, there's no mention of when this material has to be provided elsewhere. So I just don't see that how this is necessary for the limited purpose of the preliminary hearing, particularly in light of all the other three categories of evidence here. I think this is why Mr. Novak couldn't talk about whether or not this discovery material of expert material would affect the probable cause determination. This is why the Lopez analysis is so important, is because you can hear the evidence, you can listen to it, and you can say, you know, there's the confessions, there's the circumstantial evidence, there's the video evidence, and then there's the DNA evidence. I don't even need to consider the DNA evidence. And there's probable cause here. And that's the state's position, is that there's probable cause regardless. And there's no showing the defense can make that would say it's going to undermine probable cause here. That whatever their experts say, best case scenario for the defense is they get an expert that says both labs messed up. It doesn't affect probable cause because you weigh the evidence in the light most favorable to the state with relation to the DNA evidence. And there's all this other evidence anyway, a confession. That's clearly probable cause. So I would ask the court to hold off, deny the motion for now, hear the preliminary hearing evidence, and then let the defense make their showing. And if they can make a showing that undermines probable cause, fine, give them their continuance. And at the same time, have them tell us exactly what data files they're talking about here, because that's exactly what I asked for, and they gave it to me on March 24th, less than a month ago. So that's the process I think you should follow. And, you know, I know the other thing the defense has said is, look, the state doesn't have to use this evidence. They're right, we don't have to use the evidence, but we're not going to not use it where the rules allow it. We're not going to back down because of an argument that's meritless in our view. We're entitled to use it, we're going to use it. If the court decides not to rely on it, that's fine. You know, so that's my position on that.
Final question, and I appreciate both sides in their presentations. Is there a reason that you recognize that the defense would be entitled to a continuance?
Well, I think there's two components to that in my mind. First is, you know, in a lot of cases, we will stipulate to a continuance, you know, out of professionalism, preparation. You know, there's a lot of things that we stipulate to continuances on, but generally we're talking a 2-week, you know, maybe a month continuance. Here, this is a significant continuance that we think violates the victim's right to a speedy trial and affects our ability to get justice in the case. But the second component is why, yes, we would absolutely stipulate to a continuance under some circumstances. This case, it's hard to say because there's these 4 different categories of evidence that I've told you about. And the failure of any one doesn't mean the rest fail, right? Each one of these categories of evidence really establishes probable cause on their own. So it's hard to say why we would agree to a continuance in this case. You know, I mean, I'm thinking of a recent case I had where defense counsel's father died right before trial. I stipulated the continuance. Okay, something like that happens. Of course, we're going to extend that professional courtesy to the defense. You know, as it relates to preparation, I don't think the defense needs to. And this kind of goes to your question to defense counsel. Hey, are you going to render effective assistance? And I'm thinking, you know, if I were in your shoes and they say they need more time to be prepared, yeah, that's a legitimate concern. And would I agree to a continuance for them to be prepared under certain conditions? Absolutely. You know. For example, let's say they hadn't reviewed the 35 exhibits we're going to present, right? We've narrowed it down, you know, given greater notice than is required by the expert notice statute. In fact, you know, more than a month's notice of all the exhibits and witnesses we're going to call. There's 6 witnesses we're going to call. There's about 35 exhibits we're going to provide. Most of those exhibits were provided to them clear back in 2025. The last one I think was provided maybe, I've got it on a list here, but I know you have it in that letter I sent to Novak, but the last one was provided there's a tool marks report that was provided March 12th. Okay. So under these circumstances, no, they can review these 35 exhibits. We've got plenty of time to review them. I'm sure between all of them, they've reviewed all these exhibits. They're the DNA reports. There's photos of the rifle found, photos of the rounds in the rifle, surveillance video of the defendant on the scene, video of the shooting itself from people in the crowd, those type medical examiner's report, doorbell camera video of the defendant approaching in his car. The defense has all this. They can be prepared on time. So yes, there are circumstances, but I don't see them in this case.
Thank you.
Your Honor, may I go back to the request that the court made for a little more clarity? Exhibit F to our motion is Mr. Burt's discovery letter, which Mr. McBride and
I thought I talked with my hands.
And Mr. Burt is prepared right now to tell the court which pieces of the discovery letter we view as core discovery that we're entitled to before the state offers any DNA evidence at the prelim, and which pieces of that discovery letter are more in the nature of expert notice under Daubert. So if the court wants to hear from Mr. Burt right now, we don't have to delay that, but I want the court to understand that Exhibit F is probably the template for that.
All right, and I'm happy to hear from Mr. Burt. Is more time needed, Mr. Novak, to confer on what, to my first question about the discovery that's been reviewed?
Yes, I think that
might-
would have to happen during a short break.
Would a 15-minute break help accomplish that?
Very much so. I'm sure others would appreciate it.
All right, well, let's turn to Mr. Burt, and then the court will take a 15-minute break, recess. Mr. Burt.
So, Judge, to simplify a pretty complicated issue, this DNA testing, it's a black box technology. That technician processes a sample, puts it into a genetic analyzer, and what he gets is electropherogram, these little squiggly lines. I'm sure the court's familiar with that. But the machine that they put the sample into generates internal electronic files. And when the FBI or the ATF analyzes the samples, they can adjust the parameters to decide how low of a level do they want to look at the sample. And they have set standards. If it falls below a certain level, they don't want to look at it. That's just the way they do it. And in this case, what you have on all the samples, they're what are called complex mixtures, up to 5 people in each of the samples. So when they have that kind of a situation, then they use another software program called STR Mix. And they run this program, which also has internal files. And that program supposedly sorts out whether various people can be identified with a sample. So of the information we requested initially, way back on September 16th, we requested all electronic files. And in dealing with the FBI and the ATF for many years, when you make a discovery for electronic files, they know, Mr. McBride might not know, but the FBI and the ATF knows that what you're talking about when you're asking for electronic files is the machine output that can be used by another expert to reconfigure where the DNA readings are taking place. And they can only do that when they have the underlying electronic data from the genetic analyzer. So the FBI was given our initial discovery request, and I don't know, I've done probably 100 cases with either the FBI or the ATF. And when you ask for electronic discovery, you get 2 things. You get the case file, and that contains all the underlying notes of the analyst who is processing the scene. You get the electropherograms, which are the little squiggly things. And you typically get a disk with the electronic files on them. Those files cannot be read by lawyers. It requires software that lawyers typically can't afford, $10,000, $20,000 for the software packages, but they can be analyzed by the experts. And that's the information that we're asking for here. And so it's not correct that we didn't ask for this stuff in the beginning. We did. We did have a subsequent discussion where Mr. McBride said, I'm unclear on what electronic files mean. And so I did provide in a letter specifying exactly by file extension names, exactly what that meant. And in the discovery letter we sent to him, to answer the court's question, what's essential here, item number 6, data files, please provide copies of all computer data files created in the course of performing the testing. And then it specifies both raw data and processed data. These files should include all sample files, FSA and or HID files, matrix files, standard files. Any DNA expert would look at that and know exactly what we're asking for. And again, it's standard. It's all it is pressing a button. They can put that on a disk and give it to you within the day. But for some reason, it wasn't provided. And so that's item 6. That's essential information. And the second essential piece of information in this discovery letter is item 9, the STR mixed data. And under that category, we've listed 6 elements of the electronic data related to the XTR mix. The rest of the discovery requests are broader in scope. And as you were told, that's going to be worked out. But the 2 key elements that we don't have are 6 and 8, or 6 and 9 in this discovery letter. If we had that information, we could get it to the experts. The experts could look at it, see how complicated it is, give you better estimates how long it would take to put together their analysis. And their analysis, we have to depend on them because we don't have the expertise or the software to be able to read these data files.
So, and I appreciate that clarity. That's exactly what I was looking for. My next question is, let's hypothetically assume, and the court is not trying to indicate any direction.
Sure.
But let's hypothetically assume I say that's not necessary to move forward at the prelim. Is your expert ready to testify?
Ready to testify at the prelim?
Yes.
The expert would be prepared to come in and explain to the court what they could opine based on the information they have. But the bottom line of the opinions would be what they stated in their declarations to the court. Without the underlying data, it's impossible to draw conclusions. Part of it, the issue here, the specific issue is the STR mixed data that we're asking for includes the internal validation records. The internal validation records tells the lab how many people in a mixture they can reliably assess using the software. And we cited some cases to the court in the continuance motion where courts around the country are struggling with this issue. There's a certain number, if you surpass, that you can't reliably sort out a mixture. So the experts would come in and tell the court that, but they'd also say, till I see the internal validation files, the underlying data files, I wouldn't be able to tell the court whether they can reliably sort out these mixtures or not, because I haven't looked at what their files say.
So
I can
and
appreciate that this lawyer
My
is
question
talking
having
faster.
received the lab notes. I understand. It sounds like in order to simplify it, there's some internal settings for these machines, calibrations and such.
Right.
That is separate than lab notes. Where
Right.
Now, I just want to make sure I'm on understanding. Have you received the lab notes for the DNA that the state is intending to move forward on as they've given you notice? Have you received that data?
We've received the case file, the lab notes, I'll call them, from the FBI, not the ATF. So we're missing the ATF lab notes. We do have the FBI lab notes, but those lab notes will tell you how the sample was processed up to the point when it was put into the machine. It will not tell you anything about whether the machine reliably spit out the number of contributors in the sample or how they sorted out, how they're matching one of the 5 or 6 people in each sample to Mr. Robinson. That's where we're lacking the information. So I can and have reviewed the lab note files. That tells me how they process the sample. But the critical issue here is, can they reliably sort this out given the complex mixture that they're dealing with? And so that question cannot be answered based on the information that we have and we reviewed.
Thank you, Mr. Root. I appreciate that.
Thank you.
Everybody says hi.
All right, let's go ahead and we're at the 12 o'clock hour. Let's break for 15 minutes. Come back at
Everybody said hi. Do you want to say hi?
15
I know.
to
Okay.
confer with defense in regards to discovery, and then we're going to transition to talking about the media in the courtroom. As indicated, it's not the court's intent to issue a ruling about continuing the preliminary hearing. I want to weigh the evidence, the oral argument, the information today, but I am also cognizant of the timelines, and so that ruling will not be delayed because both parties require that, as they should. With that, court is now in recess.
Thank God. So court is in recess, so you're going to mute it, but we are going to go back to being live because he is back. But we are going to talk about really quick. We are going to finish what we are going through before we started this. So I'm going to stop showing that. I'm going to go back and I'm going to put my Ko-Fi up because now we have a truck payment. Things that happened during my stream. Mr. Squid bought a new truck. Yes. So if you're on Replay Crew and you saw me leave, it's because Mr. Squid got a new truck. I'm excited. But at the same time, like, you know, he said 3 days ago that he was not getting a new truck because he's not getting a new truck. My dad tried to tell him to sell his truck and get a new truck, and he said no. And now he randomly shows up on a Friday afternoon with a Chevy sales guy, and Yeah, about that. So before we started watching the shit show of a defense. What? What, Nana? You want to call Nana? Nana said bye?
Yeah. No, I didn't.
I have absolutely no idea what that was about. I'm assuming she tried to call my mom and my mom didn't answer because she ran back in here with my phone. That, you know, she gave me my phone, picked up her pad, and you know. So, hey, Lost in Space, what in the what the truck? Yeah. New, 2026. Yeah. Yeah, I know it's back, but we got to finish what we were working on before. So neither one of these are the actual bullet in question. However, these are the only two in my repertoire that I have that I could easily put. This is a 300 Blackout. This is a 338 Lapua. This is more accurate to the distance that a 30-06 would travel and the size. But when they were talking about the bullet fragments, the projectile on this is more accurate to the projectile on a 30-06. But this is the diameter. So this is the diameter of the projectile. This is a 300 Blackout, 30 caliber. But this is more of the size. So when they are talking about fragments and peeling back fragments and lead scrapings, they are talking about very, very small pieces. Think about something smaller than this, split up into 6 pieces. So it's interesting to see that. So we are going to finish this. Yeah, and we're going to watch it at 1.5 speed to get through it, but we are going to finish this ATF report that we started before the hearing commenced. So Exhibit 2 cartridge case was identified as having been fired in the Exhibit 1 rifle. Exhibit 3 through 5 consisted of 3 30-06 Springfield caliber unfired cartridge, each bearing a Remington head stamp, which for reference was the markings on that. What got interesting is Exhibit 2 cartridge and Exhibit 3 through 5 cartridges were examined for the presence of comparable tool marks. Tool marks were located on the exterior of the Exhibit 2 cartridge and Exhibit 3 cartridges, scribe marks, that are consistent with being produced by engraving and or rotary cutting tip, commonly found installed on handheld rotary tools, such as a Dremel. These tool marks can have value for comparison if a tool is located. So there's another piece of evidence that the bullet might be inconclusive. The projectile might be inconclusive, but the rest of the evidence that wasn't mentioned and that they wanted to keep secret because the defense wanted this motion with this exhibit to stay hidden and to stay sealed. And I wonder why. Exhibit 6 consisted of 1 30 caliber class deformed, damaged bullet jacket fragment, designated 6A, and 4 lead fragments, 6B through 6E. The Exhibit 6A bullet jacket fragment could not be identified or excluded as having been fired from Exhibit 1 rifle based on agreement of all discernible class characteristics, and neither sufficient agreement nor disagreement of individual characteristics. The result of the comparison was inconclusive. Firearms that produce general rifling characteristics similar to those observed on Exhibit A bullet jacket fragment included numerous makes and models. Yeah, rifling is not that like let's be honest here. Rifling of a barrel is not unusual. You can see rifling in a barrel pretty easily. And all makes and models have rifling in a barrel. You can see it. There's little lines in there. That's rifling in a barrel. Welcome to my, like I said, I'm not an expert, but we know enough. I'll put that back together when I'm done. Yeah, I don't actually own the most antique thing we own is a 1946 Mosin Nagant, but it shoots a 5.56. So it's calibered in 5.56, which is weird to me. There's a lot of stuff that doesn't add up. There's a lot of stuff that doesn't add up. But one of the things that does make a lot of sense is just because the bullet can't be identified, the projectile itself doesn't mean the rest of the stuff does not provide probable cause and enough reasonable doubt or beyond a reasonable doubt. Exhibit 6B through 6E lead fragments are not suitable for microscopic comparison, probably because they are so tiny. So just remember, and that weapon is operable. So we started this before the hearing. So I just wanted to make sure that we finish it. Yeah. Everything feels a little weird, but this is where I can't wait for the actual trial so that we can see all the evidence, especially the metadata on those text messages. So, and now we will get back to the hearing and we will watch it quicker because, you know, that's what we do. Settings. Let's watch Kathy Nestor try to explain some stuff.
Preliminary hearing dates. I just want to note if
It was his grandfather's.
In session. I wanted to give it a little bit extra time to ensure defense had that adequate time to have that discussion. What we're going to do is I'll hear from defense about that issue, and then we're going to take another brief recess. We have a technology issue that we want to address that will assist when presentation of the evidence from both sides for the next portion, and I want to make sure that's seamless. All right, Ms. Visser.
Thank you, Your Honor. Our intention is for each attorney to briefly discuss where they are at as far as rendering effective assistance of counsel at the anticipated preliminary hearing dates. I just want to note a few things. For my part, I have been doing my very best to keep up with all of the discovery productions. I certainly have not read everything, but I think it's important to note that we are just starting to find what we're missing. Although the state has indicated there are 35 exhibits for the preliminary hearing, as this court is well aware, we'll have law enforcement witnesses that also testify to hearsay from other law enforcement witnesses, which means we need to read all the law enforcement reports, right? We need to review all of the interviews that are likely to come up in that testimony. So we are in the process of determining what reports we're still missing, and there are some still missing, and what interviews we are still missing. And we are still missing interviews. And we haven't sent an updated list to the state as of today because we don't want to piecemeal it. We don't want to just ask for one thing at a time because we know it's a process to go to the law enforcement partners, get it to SBI, SBI get it to the state. But we are creating a list. And the discovery in this case, the only way I can really describe it is that it is like a living, breathing organism, right? Every time something comes in, we have to check our list, see if it's something that we've been waiting for, something that we've anticipated or requested. So if the court is asking me personally, if I feel like I'm ready to render effective assistance of counsel in May at a preliminary hearing, the answer is no. Both because there is not enough time to determine everything that we are missing and get that requested and review it in sufficient time to render effective assistance of counsel, and just the sheer magnitude of what we're dealing with. We're dealing with dozens of law enforcement agencies, hundreds of reports. We are going through it as quickly as possible. But of course, the most important thing to us is rendering effective assistance of counsel. So if the court is asking my opinion of me right now, the answer is no.
So, Ms. Visser, I appreciate that. When will you be ready? With
So
what you have right now.
with what we have right now,
Never.
so this is one of those things where you're ready.
This is where she can't answer either because they never will give you a straight answer. And this is what I hate about the defense. They will never give straight answers. When will you be ready? One, I can see just from anything. When will you ever be ready? Could you always be more prepared? Yes. However, this is a probable cause hearing. This is not a trial. You don't need all of the discovery and every piece of evidence to be gone through thoroughly by every single person in order to get through a preliminary hearing. Usually preliminary hearings are done pretty damn quickly, not 9 months after the alleged crime. That's what I can't understand. And almost 8 months out already, and we have not even had a plea. How many hearings have we had and we still haven't had a preliminary hearing? This is what's not fair to the family. And whatever you think of Erica Kirk, there's 2 children who are now growing up without a father. And yes, we make fun of the defense attorney. Yes, we make fun of the prosecution. But on this channel, we are always cognizant of the fact that a man, whatever you thought about him, whether he was your favorite person, whether you didn't care, didn't know who he was, or whether you despised him and everything he stood for, a man is dead. And we do have some dark humor from time to time around here, but we are always cognizant and we never make fun of death. The Tanner Horner, we is probably my exception to that this month, but I will never be on this channel advocating for wishing for someone to die. That is not what I do. So we are always cognizant. I've seen so many videos lately on TikTok and stuff about wanting people on the other side of the aisle than you to unalive them. It's no, we make fun of people, but at the end of the day, we have to be aware that a man died. 2 children no longer have their father. So I'm so sick of defenses or anybody delaying stuff when it doesn't need to be delayed. Yes, you are representing your client, but when does it just become a delay tactic and a stall tactic because you know your client is guilty? And when is hiding and bitching about the media and bitching about the coverage crossing a line from you're protecting your client to I'm protecting my client from the embarrassment of what he did? There was an autopsy. The autopsy was done September 16th. You heard a certain former conservative activist on YouTube say that there wasn't, but she later corrected herself and said that there was an autopsy. There was an autopsy, and in fact, even the ATF, because if there wasn't an autopsy, they would have never got the bullet fragments. So even the ATF report says, even the defense's stuff said that the bullet fragments were removed from Charlie Kirk's body. I'm trying to see where I read it. 1 bullet jacket fragment and 4 lead fragments were recovered from the body of Charlie Kirk during his autopsy. So there was. It just, yeah, you don't need to go into the qualifications, test reports, training, calibration reports. That's for trial. I think they're putting the cart before the horse because I said it before, and the more I'm thinking about it, the more I'm convinced that they are taking advantage of the fact that a lot of people who are covering this case in the media, whether it's YouTubers, the mainstream YouTubers, conservative, liberal, whatever, they are more political pundits and they are not trial watchers. Whereas trial watchers know that this is not the way this shit happens. Whereas the average person couldn't tell you how a trial goes and what the facts leading up and what the process leading up to a trial. You don't get everything on day one. It's just not how shit works. This is not how stuff works. And at the end of the day, yes, Charlie Kirk was a very popular person and a very well-known person, but he was just a civilian. He was not a politician. He was not a member of like a royal family. He was just a civilian, and his homicide case is going to be treated no different than any other person's as far as the court. It just seems if you watch Sean Ryan's podcast, the head of Charlie Kirk security was on Sean Ryan's podcast, and he goes into that. I am not going to get into that because I don't talk conspiracy theories on this channel at all. We do facts and what's in the documents on every case we cover. I do facts, what's in the documents, what the judge says, what the lawyers say. But Sean Ryan's podcast, I believe back in, I want to say December, I believe. If I can find it, I will post it to my community page. But he talked to, and they asked those specific questions. Why the college did what the college did, I don't know. I have absolutely no idea. But from that perspective, those questions were answered. So.
When you have to be ready.
And
right?
now Mama's
Based
got
off
to
of
use the.
my calendar and what I believe.
I will be right
need
back.
Personally.
All this liquid.
Well, we need the DNA. So.
Well, let's focus
outside of the
only
DNA?
on what you have, what's before you now.
I would say I need at least 4 months to finish processing what I have based off of my calendar, my trial calendar.
All right. Thank you.
Thank you.
Good afternoon, Your Honor. Kathy Nestor on behalf of Mr. Robinson. I don't know if you recall, it's been a long time, but when we were first setting this prelim, I mentioned to the court that for the months of February and March, I would not be available. I was involved in a murder trial in Summit County. And so for the entire months of February and March, I was not able to work on this case. The trial ended, I think, March 17th or 18th. Then I got sick for like 10 days. So I have not been able to turn back to Mr. Robinson's case until the beginning of this month. In the time that I was in trial, we've had 7 disclosures from the state. Many of those disclosures involve thousands and thousands of pages. One of the biggest disclosures we got was on March 5th while I was in trial, and it consisted of the entire FBI file, which was massive. That's what I've been focusing on the last 2 weeks, reading it as fast as my eyes can read it, because a lot of the reports I think that are going to come out through the FBI originated through interviews with the FBI. So I've been trying to get my head around that file. And that's just one portion of one of the 7 disclosures. And there were thousands of pages. And I think I've made it through the FBI file now, but I haven't even touched any of the rest of it. And as lead counsel, I do expect to have at least a portion of the witnesses at the prelim. I share Ms. Visser's concern about, even though there's only 35 exhibits they're going to introduce, that doesn't limit the testimony that's coming in. And I feel like if I'm going to do a job, a good job, that I need to be able to be familiar with everything that officer has touched, and really what the SBI has done generally. We went to examine physical evidence this past week. This week, it took us 6 hours. We did finish what the SBI has. However, we still have never seen the gun. The gun is at Quantico. So we've never been able to look at the gun. I actually think that's really important for purposes of the hearing. So I have some concerns about that. I also have not been able to get into my client's phone. The electronics that we have required an expert because they're so massive. We had to all get these huge hard drives shipped to us from our digital expert. I have not looked at my client's phone, and that concerns me, especially because the state's indicated they may call individuals uniquely connected to my client. I'm not going to say who because I don't want to commit you guys if you call them or not. But we've been given the names of some witnesses they may call, and what is on my client's phone I think is going to be really important. So I would share Ms. Visser's request for 4 months. I will tell you, I handle quite a few murder cases in the state. I think my last murder case that we had a prelim, we continued it, I think 3 times, and there was 2 terabytes. This case has over 200 terabytes. So I think in the scheme of preliminary hearings and timing, this is not unusual or out of the ordinary for a homicide case in the state, especially one that's complex. So personally asking for a little more time, setting the DNA completely aside. Even if the court, even if they get up and say, forget it, we're not going to introduce the DNA, even if you say, I'm not going to listen to the DNA, the rest of it is still significant. I also have some concerns that we do have a notice of intent to seek death with an aggravator. So I assume we're going to go forward with that at the prelim. No one's discussed that. If that happens, that does require really careful review of the scene itself, which I don't know that we're there yet, but we're close. I mean, we definitely have looked at so many videos. I think I've memorized the face of everybody in the crowd. But if we're going to go forward and the court has to make a decision, if you're binding over on whether or not it's capital, whether or not there's an aggravator, that's a whole nother section we have to get into. So for all the same reasons, I would ask for 4 months at least. Thank you. Your Honor.
Thank you, Ms. Nestor. Mr. Burt.
Oh, are you talking about the, Gail, are you talking about the Nick Shirley law that they're trying to pass?
I've
That's
had
just-
two primary assignments in the case. One is dealing with a media litigation, which has taken substantial amounts of my time. And I'm responsible for putting the hearing on today and working with the experts. And so a lot of my time is spent devoted to those kinds of preparation issues. In addition, I've been assigned the task of dealing with all forensic issues at the preliminary hearing. And those efforts so far have involved me sorting the discovery as it comes in, because it's not come in discrete packages. Discovery dump 1 might have some DNA discovery in it, and the next time we get something on DNA is in discovery package number 4. So part of my process has been going through everything as it comes in to sort of sort and get organized the various areas of discovery. And so far we have information coming in on the following areas: autopsy experts, canine deployment, crime scene photographs, DNA, fingerprints, firearms, footwear, laboratory intelligence unit discovery, question documents, state forensics, and trace evidence. So I have set up files for each of those areas. I'm uploading and organizing and reviewing discovery as it comes in each of those areas. We are retaining experts at the point in time when we feel we have enough information so that we're not paying experts to have to duplicate or do discovery review in batches. We're taking on the burden of getting it organized so that we're not spending a lot of expert resources on reviewing discovery. So we have retained the DNA experts and we're stuck on that issue. As you've already heard, we've retained a firearm expert who is awaiting the case files from the ATF. We just got in the second to the last discovery batch the autopsy photographs that were produced in September. I think we got those just in March of this year. So those are being reviewed and organized so that we can hire a forensic pathologist who will review the autopsy report and prepare us to do whatever cross-examination we need to do on that report. But we have not yet retained that expert. So that's kind of an overview, and happy to answer any questions. I don't feel
Which
given
you
the
don't
discovery
need,
and the complexity of some of these forensic areas that I'm in.
and you don't need to have retained a forensic expert, a forensic pathologist before a preliminary hearing. It's a do we need a dictionary? Like, I have Black's Law Dictionary right here, but do we need a basic? I have a medical dictionary and wait, let me see. So I have a medical dictionary and a Black's Law Dictionary, but I don't have an actual dictionary. But do we need to look up the definition of preliminary for these mofos? Because preliminary, this is not a trial. Like, this is not a trial. You do not have to have every shred of evidence and every expert retained before a preliminary hearing. They are trying to take advantage of people's stupidity. And this is why I hate fucking attorneys. Like, this is why I hate fucking attorneys.
Position to render effective assistance. The DNA expert estimated 6 months. I think if we got the minimal 2 categories of information that I outlined for the court, that we could expedite that down to approximately 4
All
months.
right,
so that
I'm
they'd be
putting my
prepared in
side
that
check
time
back together.
Thank you, Mr. Burt.
Thank you.
Mr. Novak.
Yes.
I've already been told I used too much of the court's time, but I think I can supplement.
No, I appreciate
No shit, Sherlock. You have wasted the court's time.
all the efforts of every party, and I know it's important, and so that time is necessary and needed. So I appreciate hearing from you.
I'm not going to represent the
Oh, and for those of you who don't know, my side chick is a Springfield XD40 Mod 2.
I'm responsible for all of the motions and pleadings that have been filed, but I've really devoted my time to writing. And obviously the court has held many substantive hearings on issues so far. Obviously, everything that we write is a collaboration, but I think that the vast majority of the time that I've devoted to this case has been the legal writing and frankly, coordinating the mitigation investigation, which I'm not going to talk about beyond saying I speak almost daily.
And it's
with people
locked
involved in
right there,
investigation,
but it's next to me
reviewing
at all
materials.
times.
That's one of the things. And
Go get a-
obviously, that's
go
not
get a
part of the
washcloth.
prelim. So if we were shifting to fulsome preparation for the preliminary hearing over, say, the next 30 days,
Yeah.
I would have to basically put aside all the writing that needs to be done and direction.
Go get a washcloth. Your pants are not a washcloth.
And figure out where, with my colleagues, they need me to fill in so that we are all constitutionally effective when it comes to the preliminary hearing.
And so if, as it relates to what you are,
Mine too. I'm not a lawyer. I never claimed to be one, but I've watched enough trials to know basic things. And I just speak as a jury member or prospective jury member, and someone with common sense. But I like to call out lawyers on lawyer bull crap. I like to call stupid when I see it. And I really don't, I never care what side I'm calling stupid. I just call balls and strikes as I see them. Usually I hate the state because I'm an anarchist. But you know, I also call defense attorneys stupid when they're being stupid. So, yeah.
or maybe assigned to as it relates to the preliminary hearing, how much time would you need?
I think the estimate of my colleagues of 4 months is appropriate. And I also think that what we are all saying is whatever time our DNA experts need once they see the data that Mr. Burke so eloquently explained to Your Honor, we don't have, that's really going to be the controlling time period. We're not going to say, oh, our DNA experts are ready, but counsel are not, because I think that 6-month estimate by our expert, which was provided in a declaration, is going to be the outer limit. But that's going to be from when they actually get the data. And as Mr. Burt said, there may be a refinement of that once they see the data that's available to them. I mean, that was sort of a best assessment based on past experience, not based on what the data in this case presents in terms of the challenges for analysis.
Thank you, Mr. Novak.
Thank you.
All right, as anything, just turning to the state, any benefit of the record that's needed?
I would just add, I haven't seen everything in the file either. That doesn't stop me from being prepared. This is a massive file. Probably, I don't know, 70, 80% of the file is running down leads that did not lead to any fruitful evidence. And so a lot of what this is categorizing evidence. And the core evidence that's required at the preliminary hearing has been provided for a long time with the intent that I could help the defense. And this is exactly what I said in my letter that I wrote to them with the witness and exhibit list. I provided very explicitly the witnesses we would call, the Bates numbers of the reports that talked about the witnesses that we would call, including the Bates numbers of the reports of the witnesses we would use 1102 statements for. I included all the exhibits, the Bates numbers for those exhibits, the dates on which those exhibits were provided for the defense. I see no reason why the defense can't review that material. We could probably review it in an hour or two with them, and they could sit down, look at those exhibits, look at those reports, and be prepared for the preliminary hearing, Your Honor.
Thank you. All right, thank you to all parties. I appreciate that guidance. I made note of it. As indicated before, we will take another brief recess. We just need to get technology set up to ensure that it's seamless as you're making your presentations. And we'll break, come back at the 1 o'clock hour. Counsel also uses time to prepare. So when we start at 1, we're ready to jump in. We'll start with defense, and that way we can be efficient with our time. Thank you. Court is now in recess.
All right, and let's see if they are back. And they are not. I think I'm going to call it a day for this. We will cover the rest of it at a later time. The rest of it is going to be, once again, the talking about the media in the courtroom. I am so sick of them talking about that. I don't know about any of y'all. We've been at this for 3 hours. I did appreciate what they did with the talking about the preliminary hearing. However, talking about the media in the courtroom, it is more of the same BS from the defense. We have the documents. We can go over the documents next week, but it is just more of my clients. Not a fair trial, not a fair trial, not a fair trial. It's not a fair trial, not a fair trial, not a fair trial. So
No objection to introducing these.
we'll see what they have to say, but I don't want to stick around Exactly. I believe all courts should be recorded, even federal, especially federal, because that is where the most egregious shit happens. It's
Court is now back in session.
That's a good point.
Turning to defense, are we ready to proceed?
Yes, Your Honor.
Thank you, Mr. Burt. We'll hear from you.
Your Honor, by way of introduction and to expedite things, we've prepared for the court a binder with all the exhibits in it. I've had it marked as A, defendants A.
All right.
And within that binder, there are 12 exhibits. And I think because of the time limitations regarding the hearing, we do have an agreement that there'd be no objection to introducing these exhibits. And I believe the state also has a report that they want to put into evidence. We have no objection to that. So I'd like just briefly to review with the court what's in this exhibit binder.
The defense doesn't want the public aiding the prosecution, perhaps. Well, there's also there's an interesting conundrum with that, because I see it differently. I see it as there are so many conspiracy theories right now that the defense can easily go, well, you see this, you see this, you see this. There is so much there are so many theories out there that it's so easy to prove introduce reasonable doubt into this situation, which is part of the reason that I don't ever want to contribute to the conspiracy theory crap, because of the fact that my name has ended up in multiple court docs before. One, I don't ever want to be in that situation again if I can help it. Secondly, we're in a situation where anybody that says anything on YouTube, you could, in fact, introduce or become evidence as to why reasonable doubt is there. And I don't want to do that either. Oh yes. Oh yeah, I used to love her. I just feel like certain people have gone off the let's use critical thinking and let's use critical thinking and not introduce more crap like that the defense could use to introduce reasonable doubt. And I just that's a whole nother topic for a whole nother point. But so I can see both, Island, I get what you're saying, and I agree with you to a point. I can also just see the other side of it. So it's a weird conundrum that we find ourselves in. So, yeah. Yeah, I used to, and I'm not gonna lie, I don't really follow, since I had a child, I don't really follow much. Since I started a YouTube channel, I really don't follow much, because if I'm going to be prepared for my own stuff, I don't have the time. 2 YouTube channels, 2 out of the house jobs, still considered a stay-at-home mom, chronic medical condition that I have to figure out. I have a CrossFit competition tomorrow. Life is I watch Charlotte Dobre kind of videos to decompress other people's drama. I don't really watch a lot of everybody. Yeah, and that's the other thing. Only one side is trying to keep cameras out. It's just, and that's one of the reasons that I can't wait to see the trial, because that's when we will get the actual evidence. Life is life, and yeah. And now we have a new truck. I honestly can't wait till Mr. Squid gets home so I can see the Mr. Squid should be home within the hour. So I have about 40 minutes left. So we're gonna get to
The court
this.
has an overview of where we're going and what the evidence involves.
All right, so Mr. Grunander, I notice you standing.
I was simply going to just indicate that that is an accurate report with respect to the stipulation from the state.
Thank you. I appreciate the parties working together to streamline. That makes it easy for the court. So thank you.
So Your Honor, in light of the agreement, I would move into evidence the exhibits that are in the binder exhibit A, it would be A1 through 12.
All right, and per stipulation, they are admitted into evidence and may be published at your discretion.
Thank you, Your Honor. Second of
wheel
all,
of justice
we
turns
put
slowly.
on a hard drive that we're marking as Exhibit B, all of the PowerPoints that are going to be displayed for the court, all of the scientific studies that are going to be cited by Dr. Ruva, as well as the underlying videos that are going to be displayed. Some of the videos are, because of the time limitations, have had to be edited. So we get to the gist of what we want to show to the court. But the entire video clips are on the hard drive if the court wants to look at it. I've also provided a document of all the transcripts of all the electronic media coverage from September 10th through today. It's about 6,000 pages.
I see.
But I just, in case the court wants to look at any of the material, the actual full context of some of the clips we're going to show the court, it's there. And in terms of what else, so I moved that into evidence as well.
So that would be Defense Exhibit B.
Correct.
All right, and
No objection for the purposes of this hearing. And I would just say, Judge, that while these are being received into evidence, the state has no objection for the purposes of this hearing. If we move to another sort of challenge with respect to venue, for example,
I see.
we may have to revisit any sort of stipulation.
Thank you, Mr. Grunander. And just for the benefit of both parties, I meant to start with this. So we have a monitor set up here for a court reporter. I just want to make counsel aware that it could be picked up on the camera, the transmission. So if there's something that should not, please make the court aware and we can adjust accordingly. But I just want to make aware so our court reporter can look and accurately make note of what's happening in court. So just FYI.
Thank you. And Your Honor, just in terms of what's in front of the court in Exhibit A, tab number 1 is the CV for Dr. Edelman. He will be our first witness, a social psychologist and the person who conducted a survey of the community opinion. He's going to talk about that. The survey he conducted is tab number 2. Tab number 3 is his PowerPoint, which is very lengthy, and there's no way we're going to be able to get through it in the time allotted. So I'm going to do the best I can to summarize it for the court. Tab 4 is Dr. Ruva's declaration, and Dr. Ruva's, Christina Ruva, R-U-V-A's CV. She will be our second, and we're only going to have 2 witnesses. We're originally going to have 3. We've condensed it down to 2.
Okay.
So you have her CV on tab 4. Tab 5 is the report she submitted in support of the motion that we filed back in December. Tab 6 is a supplemental report that she wrote after the state and the media filed their opposition to the motion. Tab 7 is her PowerPoint, again, very lengthy, and because of its length, we're not going to be able to present the entire thing to the court. 8 is a document that is currently under seal. It's a declaration of Amber Robinson, and the court has sealed that. So one of the issues is whether it should remain sealed. And it relates to the issue of the privacy prong of the rule that indicates the court has to take into consideration privacy concerns of witnesses and others. So that is currently private. 9 is the declaration of Mashi Robinson, also private. 10 is a declaration of Ms. Nestor regarding some threats she has received. And that's, we're not offering that as private. That's something that the court can consider. 11 is a declaration from a prosecution witness whose name is Samuel New, NEW, indicating his objection to being televised and the reasons for it.
And guess what?
12 is a
Guess what?
declaration of another
Ooh,
prosecution witness, James Rawlinson.
I hate when they're doing that. I hate when they do this. I hate when they do this. Hate it, hate it, hate it. Yes, it's wrong. It's wrong for anybody to send it threatening anything. But like, y'all, you took a high profile case. This case gets a lot of media attention. You took it voluntarily. No one told you. And as far as the people who are related to Tyler Robinson, sorry, but your brother is accused of a horrendous crime, or cousin or whatever, son, whoever is accused of something horrendous. And the thing is Charlie Kirk didn't get the luxury of being able to pass away in peace by himself. He was shot in public. So guess what? Whoever is accused of his crime, of unaliving him, is going to be public too. You don't want to be on trial in public. Don't commit a crime in the U.S. or don't get accused of a crime in the U.S. Sorry. Like, innocent until proven guilty, yes. But we have this thing in the U.S. called transparency. Sucks to be you. Courts are televised. Courts are televised. Yeah, this WTF line. And this is why I use that skincare, because it's specifically for this. I call it the WTF line because you can see it when I want to go, what the? You can see these lines start to show up. And I am just finishing the little spoonful of Nutella here. So, yeah. Ah, look at the judge's face.
Indicating the same thing. And Your Honor, just to let the court know, there are over 3,000 witnesses, so we have not been able to survey any of them except the two that we're providing to the court in terms of whether they have privacy concerns. When we get to the argument, I'll be addressing that issue, but I wanted to alert the court that we do have witnesses who are, at least these two, who so far have stated their opinions.
Thank you, Mr. Burke.
So I'm prepared to call Dr. Edelman at this point.
All right, and just before we do, this may not be applicable, but just to be thorough, is either party invoking the exclusionary rule?
Your Honor, we discussed that, and I think with the agreement with the court that we would not invoke the rule, and the prosecution's expert or witness will be allowed to attend, as well as Dr. Ruvo would still listen to Dr. Edelman. I think that would expedite the process.
Thank you.
That's accurate, Judge. Generally, there is an exclusion for expert witnesses. In part, that's the reason for the stipulation. The state's witness is going to be a fact witness, but
Okay.
nonetheless, the defense is not objecting to him being present.
All right, thank you for addressing that. That does streamline things. All right, Mr. Burton, just want to call your
Dr.
witness.
Edelman?
Y'all.
Your Honor, there was one other issue I wanted to raise with the court. When the court made its ruling on the 13th, opening this hearing to the public, I believe, if I'm not mistaken, that the court reserved the issue of whether particular parts of the hearing would need to be closed. And there are certain slides, video presentations, that when we get to those, I will be asking the court to take them in camera, explaining why I think so. And we just, for the record, ask the court for a ruling.
Thank you. I appreciate that heads up.
Sure.
Here we go again.
Doctor, if you wouldn't mind coming forward, standing right here to be sworn in. Oh, sure, go ahead. Well,
So confused on why we need witnesses and a doctor for
stand right
not
here
a
to be
medical
sworn in, and then
doctor.
we'll have you
You
come
can
to the
sit.
stand.
You do
This.
solemnly swear that the testimony you're about to give now before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. Now you can sit down.
All right, if you'd like to get seated, make yourself comfortable. Looks like you brought your own water bottle, but generally we have water bottles. So go ahead and get situated and then bring that microphone close to you.
Sure.
We just want to make sure that the audio record picks you up. So okay, if you could do that, I appreciate it.
I feel so tiny in this chair. All right.
All right, Mr. Burke.
Thank you. Tell us your name and tell the court what you do for a living.
Sure. My name is Brian Edelman, and I am a trial consultant based out of California.
Oh,
And,
that explains
what is
so
your
much.
educational background?
I have a PhD in social psychology and then an LLM in international law.
What does a trial consultant do?
So as a trial consultant, I work more with attorneys and counties and other clients, more of as an advocate, I would say.
He's Bull.
And I do pretrial research such as
He's Bull. He's the dude from Bull, only not as good looking and not as fun. And probably not as effective because freeze frame right here, he looks drunk.
focus groups, mock trials. I help with jury selection, so write juror questionnaires, oral voir dire questions, attend jury selections, give recommendations in terms of cause challenges, peremptory challenges, a lot of post-trial interviews after trials are over, so post-verdict interviews. And I also work as an expert, which is different hat. So when I'm doing this type of work, it's more as an objective person, so I'm not advocating for one side or the other. So that's a different role.
What were you asked to do in this case?
Can you speak in mic? I'm sorry.
Sure. What were you asked to do in this
Sure.
case?
So at this point, what I was asked to do was to assess whether or not people in the community are being exposed to media coverage, how closely they're following it, and what their sources are. So not a change of venue survey. A lot of the work I do is in change of venue. I would not classify this as a change of venue study.
Okay. There's a binder there in front of you. Would you take a look at tab 1, please?
Sure.
He's an expert, just ask him. Well, so
Is
is
that
expert.
your resume?
It is.
And does it set forth all the cases you've worked on, either change of venue or doing community surveys, the kind that you were asked to do in this case?
Yeah, for the most part. I mean, I'm probably not all of them are in here, but yeah, these are most of them.
All right. Now, did you prepare a PowerPoint
I
for
did.
this case? And is that in tab 3 there in front of you in the binder?
Let's see. Yes.
And I've informed you we have some time restrictions here, right?
Yes.
Do you think you're going to be able to get through this whole?
I'm going to talk
PowerPoint?
really fast. I've had a lot of coffee, so I think it will be good.
Okay, good. So if I could
I'm
bring
not
that up.
ignoring
All
you. Yes, Michael Weatherly. I'm very familiar. Very familiar. And now from a new show with him and where he's back as, you and so,
Okay. So why don't you walk us through what you were asked to, or what you're going to present here in your presentation?
So I'm not going to talk about the social science literature just because Dr. Ruba is going to do
doorbell
that.
rang. I will be right back.
So, but primarily we'll focus on the extent and nature of the coverage in this case. And this isn't a change of venue study, so it's really focusing on what coverage has come out of these hearings, more of the from the video streaming and video cameras in the courtroom. So not looking at an analysis of the prejudicial nature of the coverage per se, like we would in change of venue survey. And then the second part is the survey that was done to see what impact this has had on the jury pool. Are people following it? What are they seeing? And what impressions they have at this point. So I would consider this like the baseline. This is the floor of where we're at right now. And we'll see what happens moving forward. And then the last section, if we have time, talks about some of the challenges cases like this pose when you're trying to pick a jury in a community like this.
Great. So you said on the first area, the social science literature, that's something Dr. Ruba is going to talk about, but did you have one key point you wanted to make there?
The only thing I want to say about it, because we'll touch on it when we get into the media coverage, is, there's a lot of research on this. And the main takeaway I want to talk about is the types of pretrial publicity that are most prejudicial is emotional pretrial publicity and pretrial publicity around the character of the defendant. So I'm just all I'm going to say, because it'll come up later.
Okay, so I'm going to skip ahead
Okay.
to the extent of the coverage and has the coverage impacted the jury pool?
Right. Okay. So again, this is just looking at two things. Where are we at today in terms of the extent and nature of some of the coverage, focusing on the question of whether or not having cameras in a courtroom is potentially prejudicial, and if it's creating sensational content, or is it more of a neutral nature that, people watching live streams and things like that? And then what impact has this coverage had so far on the jury pool?
And question 2 is answered by your survey?
By telephone survey. Yes.
All right. So let's take a look at the first area, the media coverage.
Okay, so I just wanted to touch on the extent of the coverage. So the data here come from two different sources. The first source is called Newsbank, and that's an archive of newspaper coverage. So when it's looking at the coverage in the state of Utah, there's 831 articles in that Newsbank that are sources that are based in the state. And it's probably a conservative number because it's not exhaustive. There's things that are missed. But I'd rather be conservative than overly inclusive.
Right.
And then Utah County, 697. And I believe it looked at like 15 sources, primarily 15 newspapers. It also includes Fox KSTU, the local Fox station, and there's 209 news segments that are in that archive. The last section there, that row, is from a Lexis search, which is different, and it captures transcripts. So there's 441 of those that are nationwide, but it is limited. So it doesn't include Fox News. It doesn't include, I think, MSNBC, NBC. So it's not an exhaustive list. It's only certain.
I'm sorry, to include CNN, the major
It has
networks.
CNN. I think it has CBS, NBC, maybe NBC or something like that. But it's missing some of the networks.
And I told the court that on his thumb drive, on his drive that we provided, 441 transcripts, 6,000 pages.
Yeah, that's right.
You've seen that.
I have seen that.
Okay. Next, I think you're going to look at the nature of the media coverage and what was the framework you used to do that?
Yeah, so one thing I wanted to touch on is this is the American Bar Association rule, so 3.6 about pretrial publicity. It's not the rule, whatever the Utah one. This is just the ABA. And the thing that stood out to me initially is when we talk about people who work in, attorneys, people involved in the case, like what they should and shouldn't introduce to the public. And one of those things that are key factors to me are extrajudicial statements that the lawyer knows or reasonably should know. Will be disseminated by means of public communications and have a substantial likelihood of materially prejudicing the adjudicative proceeding in the matter. So anything that's particularly prejudicial in nature, you shouldn't be releasing if you know it's going to lead to bias. Examples when we talk about the defendant, I mentioned defendant character evidence is particularly prejudicial. We have character, credibility, reputation, or criminal record. And then tests and things like confessions, admissions, statements given by a defendant. When we talk about tests, it could be DNA, ballistics, things like that. And then opinions as to the guilt or innocence of the defendant. And then anything they know might be admissible. So this is the stuff I look at, are things crossing that line? Because those things are particularly prejudicial. And I think the ABA, a lot of that is driven by the research that tells us that.
Okay. We're on slide 14. What does it show us?
So the reason I point this out is because a lot of the prejudicial content that's come out so far that you see in the media and keeps being reproduced on social media, in television newscasts, is what was initially released in this press conference. So, it was the, I guess the indictment or arrest affidavit, and there's a lot of prejudicial details that are distributed in there where it's, a very long press conference. We're literally reading text messages from the defendant to his roommate, and they're prejudicial. They imply there's some degree of guilt in there, and it's reading it, the whole thing, which is disseminated, and it gets reproduced on TV and reproduced again and again and again. It appears in social media posts, reels on YouTube, and a host of other places.
And does that reproduction include when the coverage relates to in-court appearances?
Doesn't this remind you of Amber Heard trying to bring in like people talking about social media? It just, suck it up, Buttercup. You committed a crime or allegedly committed a crime in a public location. People instantly posted the video on Twitter. Like, oh. Yes, this is so true. The thing about expert witnesses is you can always find two experts to say opposite things. That's true. It's opinions. Remember, opinions are like assholes. Everybody's got them and they all stink.
It does. So, we'll get to that, but the information that was here keeps getting reproduced in a sensational way on TV. And not only that, like he's reading it, but when you see it in the graphics, it shows text message that implies this is the actual text message on a phone that came from the defendant, and it's not. So it's very prejudicial and misleading.
So you see on your slide, this serves as sort of a megaphone and a distributor of certain information.
Yes, and
is within the categories you set out.
Yes, and when it's being distributed, just to point out, it's not like it's only distributed on conservative media outlets like Fox. It's on CNN, NBC, all of the networks. So it's widely being distributed to all types of networks.
And in terms of other sources,
Title, I saw it. JKD Buck took that picture. JKD Buck took that picture. If I'm remembering. Yep. Oh no, that one. Mommy. Oh, cute.
of this megaphone effect. Next, and
Yes,
by the way,
it is
we've got
me.
the actual video of the press conference.
Yeah, this is a clip of it.
We're not going to play that
Yeah.
because of time limitations, but it's there if you want to look at it. Are there other sort of
Boston's face.
megaphone factors?
I'm an asshole. What does that say about me? Oh, but I'm glad you're here. At least you find me a tolerable asshole, maybe. Like,
Sure.
Yeah, so this is a unique factor in this case, in the sense that people who are very influential, obviously the President of the United States, or former Attorney General, these are people that have a lot of influence and power, perceived credibility, and they're making strong prejudicial inflammatory statements, and I think that's unique. I don't usually see that in cases, and calling for the public execution of the defendant before there's been a trial, things like that are unique in nature.
Right, Your Honor, this is one of the slides I would like the court to see, and it's, as he just indicated, expressing opinions, strong opinions about whether Mr. Robinson should be executed. So the court wants to take it in public, that's fine, but for the record, I'm asking the court not to do that. I do think it's important that the court hear this, just the tone of it and the substance, I think is very important for the court to consider. Since we are submitting it, the PowerPoint is on the drive, the court could listen to it outside of the public domain, however the court wants to proceed.
So I'll make note of that, and I'm happy to review that in its
Thank you.
entirety.
If we're not going to play, just one thing that's unique about it, if we're not playing it, is
Sure.
there's inflammatory language in there that also creates in-group, out-group identification. When I think,
Could you explain that?
yeah, so it's like a lot of people identify with a political side. Unfortunately, I'm a member of the Democratic Party or or Republican Party. I'm liberal. I'm conservative. So I think there's some language in that clip where it mentions, I don't remember the exact phrase, but something about like lunatic leftists or something like that.
it's loony leftists and whatever Republicans. I identify as I hate everybody. I hate government. I hate everybody. All politicians lie, and nobody likes me. And if nobody likes me and everybody thinks I'm doing something wrong, then I must be doing something right. If everybody thinks you're biased or everybody thinks you're full of shit, you must be doing something to piss off both sides, in which case you must be doing something right.
Doing this, so it creates this, the out-group is dangerous, the lunatics,
This is where I like
maniacs, or
weed.
whatever phrase was used, which creates more of danger, the perception that members of that group, that out-group, are dangerous, and there's a danger there. So that's something that comes up later as well.
And how is that kind of information more or less prejudicial?
Well, it creates, again, in-group, out-group identification, and we think members of the out-group are not like us. They tend to, or they're all the same. We have to attribute stereotypes that of how those people behave. They're more likely to impact how we see them. You're less likely to have empathy for members of the out-group when group salience is high. Versus members of our group, we see as individuals or complex, less likely to be impacted by stereotypes, more likely to empathize with them, identify with them, things like that.
Right. Now, did you actually take a look at the court appearances that have so far taken place in this case to see what was discussed so that you could compare what was happening in court with what the electronic media was reporting was happening?
In terms of the comparison of what's happening and what's being produced,
Yes.
yeah, I did look at that.
So the timeline, could you explain this, what you have up here?
So this is just a timeline of the hearings that have taken place and like high level what they were. So like the initial WebEx appearance, pretty brief, and you would think that's a pretty neutral, not very significant hearing. And you would expect if you're looking at the media, it should be neutral. It shouldn't be highly prejudicial, inflammatory, since very little happened there, right?
Mhm.
And the same thing when you have like the waiver hearing, appointment of counsel. There's not a lot of fireworks. It's not the preliminary hearing. No evidence is being laid out or anything like that. So you would expect the media not to be introducing prejudicial content, given the nature of those particular hearings.
If they were serving an educational function.
If they were educational, transparent, a summary of what occurred, these are very procedural, technical things. They're not necessarily sensational in it.
So did you take a look at the first hearing, the initial WebEx appearance by Mr. Robinson?
Right. So this is a brief, short hearing. I think he appeared on WebEx, right? And then I looked primarily at what did that elicit? What was the reaction to the media? Was it kind of just summarizing this is what happened, or was it more sensational in nature?
Okay, so let's take a look.
The media
at-
is always sensational.
This is
That's
from
why you have
NBC
YouTubers.
News.
Watching that court
On that
hearing
date,
for the
correct.
man
Is it a little bit?
suspected of shooting and killing Charlie Kirk last week on a campus in Utah. You saw the suspected assassin, Procedural Tyler Robinson there, not speak.
I think we got a problem with the audio.
To thank all parties for being here.
Like, let's skip ahead because
All right, let's
this they're basically going to make a case for it. It's Amber Heard all over again. Oh, their media, they're mean to us in the media. The media is biased, and it's like, no, you can see just as many conspiracy theories about that would introduce reasonable doubt. They just want to hide their client. It's what all defense attorneys want to do. Sarah Boone didn't like cameras, but guess what? Shit still happens. So we're gonna skip ahead because I'm almost like, you ever get to a point where you're just fed up with someone's bullshit and you're just like, I gotta go? That is kind of where I'm at with this defense team right now. And they just have they have just no. The highest award for journalism is named after a yellow journalist to sensationalize the news. Okay, go get your washcloth. No water. Like, you know? And I think their audio is messed up anyway. Because this is live and we've got nothing. So, it is what it is. They're talking about us. We are the media now. That is true. And their audio is messed up. So I think this is where I'm gonna call it a day. If they're gonna hide the rest of this. Angel. So I think we are gonna call it a day. If anything interesting does happen, because she's getting antsy too. Mr. Squid should be home any minute now with his new toy. Oh, I didn't ask price. I didn't bother to ask what the price was going to be.
Okay. Yes.
But they're having audio issues, so we are going to call it a day. Thanks for hanging out with me for almost 4 hours. Y'all, thanks for, it's been a day. What have we figured out? This defense team is trying to stall, in my opinion. In the comment section, if you've made it this far, please feel free to let me know if you agree, you disagree. I want your opinions on what you think this defense team is trying to do, because they're talking about the preliminary hearing. You want to call Nana? Okay. So we will I will see you in an hour and a half. We will go over to Nick Starro. I think he has a stream set up. Yep, slightly buzzed. Peens, Owens, and Reed. Should be a good time. A good laugh to end the week. Or end the week. Because it's been a hard week between this and the Tanner Horner, the person who I'm not sure all of my niceties go away when it comes to Tanner Horner. He makes me want to do awful things. Don't they always stall? Yes. However, if you know your client is innocent, there's a point of stalling, but there's the point of a speedy trial so you can get your client through this and on with the rest of their life. Which also begs the question, if your client is innocent, why are you stalling a preliminary hearing? If your client is innocent, why are you trying to keep the media out of the shit show? Because if your client is innocent, why wouldn't you want the media going? See how they fucked up, see how they messed up, see how awful they are and how awful they were trying to prosecute my client when he didn't do anything. When someone is trying to hide something, my spidey senses go wee. So, but on that note, I will see you guys in an hour and a half over on Nick Starro. I appreciate y'all hanging out with me. Want to say bye? Bye. All right. And y'all are great, but have the day y'all deserve, and I will see you on the next one. Bye, guys. Bye.